you are, Frank.
All right, give me a second. I'm gonna let it go.
Waiting for the
here.
producer to tell me we're running here.
I didn't want to start until we were ready, so I gotta wait for the live stream to go. All right. So let's go in and start recording. Whenever you're ready, Frank.
Okay. Good evening. Welcome to the Township of Hillsborough Board of Adjustment public meeting for Wednesday, September 16, 2020, held remotely via electronic means. Please join me for the Pledge of Allegiance. I pledge
Pledge
allegiance
allegiance.
Flag
To the flag
of the United
United
States
States
of
of
America
public
and to the republic for which it stands,
one nation,
under God,
God,
indivisible,
indivisible, with liberty and
and
justice
justice for
for
all.
all.
This meeting will be conducted virtually. The public will be given an opportunity to participate remotely through Zoom by entering by following the instructions listed in the agenda. And the agenda, by the way, has been posted on the township site. Okay, all documents pertaining to any applications on the agenda were available on the township website prior to this meeting. Board members, staff, and consultants will be participating remotely. Applicants will be presenting remotely and will identify themselves before testifying. This meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, called the Sunshine Law. Notice of the 2020 annual meeting schedule has been provided to the officially designated newspapers, the township clerk, and posted on the bulletin board at the Hillsborough Township Municipal Building. Tina, would you take one more thing? Additional notice has been provided to communicate this meeting is being conducted by electronic means only. Tina, would you call the roll, please?
Yes. Mr. Stamler,
here.
Ms. Haynes,
Here.
Mr. Sirachi,
Here.
Ms. Salili,
Here,
Mr. Valchek. Mr. Valchek,
Unmute yourself, Frank.
Here.
thank you.
Thank you.
Ms. Erickson,
Here.
Mr. Walmarker,
Here.
Mr. Basil,
Here.
Chairman Herbert.
Here.
Mr. Gorman, you're here.
Present.
Mr. Anderson,
I am here.
Mr. Neff,
Here.
and I am here, and Mr. Kinsler is here.
Here.
Thank you. Fred, would you briefly explain the technology that's being used tonight for this virtual meeting and how the public will be able to participate when it becomes their turn?
Sure, we're using the Zoom method. The public will be able to participate when it's their turn. We will announce to the public if they have comments on the appropriate matter to please raise your hand. There's a button on the bottom of the Zoom that says raise hand. You'll be called on and be asked to unmute yourself. Please state your name and address for the record, and you'll be able to speak in that method.
Thank you. Okay, the first thing on the agenda tonight is consideration of meeting minutes. We have meeting minutes for July 22nd, 2020. Any discussion with board members?
Motion to approve.
Second.
Those in favor?
aye,
Aye.
Anybody opposed? Okay. Next on the agenda is consideration of resolutions. We have one resolution, BA 19-21, Bilco Construction Company. Board discussion.
Motion to approve.
Second.
Okay, Tina, who can vote on this?
Yeah, I'm good. I'll do the call here. Chairman Herbert,
Yes.
Ms. Haynes,
Yes.
Mr. Valchek.
Unmute yourself, Frank. Frank, can you unmute yourself and vote on the resolution, please?
Frank Valchek.
Mr. Valchek?
he's still muted. Okay, now he's unmuted.
Yes.
Okay, thank you. Mr. Stamler,
Yes.
Ms. Salili,
Yes,
Ms. Erickson,
Yes.
and Mr. Walmarker?
Yes.
Thank you.
Okay, next is Board of Adjustment business. Patrick, would you tell the board what happened with the file BA 2005, and the Norman Mance application?
Sure thing, Mr. Chairman. Pat Gorman here. It was discovered during the inspection of the affidavit for the notice in the newspaper that there were some errors in the notice that would sufficiently not make this application available because of the confusing nature of how it was displayed. Mark, is that pretty much a summary of what we have?
Mark is muted.
I apologize. I clicked, but it didn't get it. Mr. Foreman is correct. The notice in this case misstated the impervious coverage requirements in the zone, and that I believe is necessarily a fatal defect to the notice.
Okay, so we can't hear the application this evening, so let's have some discussion about when we can have it. Patrick, how does the calendar look?
I'm sorry, Mr. Chairman. I'm dealing with a barking dog at the moment. I apologize.
Of a barking dog. Okay, so anyway, how does it, we have upcoming meetings in October and November, right? So when can we get them back on the,
Yeah, so the October 7th, at the moment, we moved the Timco application for that night so far.
Yeah.
And it's expected the Pilgrim River application will also be on. The attorney is here tonight, Mr. Ogrodnik, who's the attorney for both the Christian Community Chapel and the Mance application. Mr. Ogrodnik, do you have any questions at the moment for the board or about scheduling, or because it's going to be a pretty tight schedule for the board to hear both Pilgrim River and Timco?
Okay, I mean, next available date, Mance is a pool variance for impervious, so I don't think it'll be a long application. So whenever we can squeeze it in when the schedule permits, obviously he's looking to build next spring.
Okay.
I mean, we could put them on the October meeting at the end, and since but you might not be heard, or we can go right to November.
Go to November, because I think it was stated that they're looking to build in the spring, Frank, so there's no rush on it. Why have them sit all meeting?
Good point.
Yep.
Okay.
November looks good, so we'll put them on for the November meeting with renotice.
Okay, next, anybody else? Okay, next on the agenda is business from the floor for matters.
Oh, no, hey, Frank, it's John Stamler. I'm not with the board business. Can you give me a status? Remember, we were looking at some target dates on the board recommendations to the township committee on those items?
Yes, as a matter of fact, I think we have some good news. Patrick, would you like to tell them what happened on the?
Yeah, so the board subcommittee is reforming and they're outlining their objectives and statements for their upcoming series. They're well aware of the board's recommendations, and they'll be considered as part of all that. But that's all I have for at the moment. The planning board meeting, I believe, is tomorrow night.
My understanding is they're actually working on one with the fire, house that burnt down. Aren't they already working with the township attorney on that?
I'm not aware of that.
Chicky, what was it you heard?
And I'm not sure if it was Mark that informed us that that there is an overriding state or MLUL ruling that a municipality cannot impose a percentage of destruction by the house. Ours says 50% or more. It makes it a total loss, whereas apparently judge ruling says it's an indeterminate amount as to the amount of destruction. So theoretically, if there's one wall standing, it could be determined that they, That's my my vast legal interpretation. But in any case, I understand that our ordinance is going to be amended to take out that percentage, because that apparently makes it incorrect or not in agreement with recent court determinations.
And if I read that email correctly, basically that's going to accomplish what we're asking, what we asked for.
I think so.
So it's been a year and we're 0 for 6, right?
Well,
Well,
1.5, half a 6.
Well,
Yeah.
we're 0 for 6. And it's been a year. Right?
true. True.
So what's the next step?
Well, then the next step is that the planning board is going to outline their goals and objectives for, to evaluate the ordinances that are presented, not these specific ones, but just overall, and re-examine with the master plan.
So we're in the same place we were a year ago.
Not necessarily.
Yeah, right. Okay, let's move on.
Any more business, Board of Adjustment business? No, hearing none. Okay, next is business from the floor for matters not on the agenda. At this point, Fred will open up the public lines. And if anybody's out there that wants to talk to the board and tell us something, for something that's not on the agenda tonight, this is the time to do that.
So again, this is Fred Kinsler. Anybody in the public who would like to speak on matters not on the agenda, please raise your hand. Seeing none, Chairman, I think you can proceed.
Good, so you can review the lines. Okay, next is our first public hearing application. Christopher J. and Kirsty Bradley, file BA 2004. Patrick, would you introduce that, please?
First application this evening is, as the chairman said, Christie and Christopher Bradley, file number BA 20-04, located at block 161, lot 4, otherwise known as 108 Meadowbrook Drive. The applicant is seeking a C variance for relief on minimum side yard setback to construct a 2-story garage addition to the existing dwelling for a property in the CR Central Residential District. Time of decision is December 9th, 2020.
Mark Anderson, would you have anything else to add to this?
Mr. Chairman, as is typical in all these applications, I was asked to take a look at the notice as published. Unfortunately, I saw this not before it was published, but after it was published, in order to determine whether it is sufficient under the municipal land use law for the board to take jurisdiction. My conclusion is that it meets the standard, but only by the barest margin. I think that it meets the letter of the municipal land use law for the board to take jurisdiction, but certainly it's not the notice that I would normally want to see. Now, my task is to advise the board whether I believe it meets that minimum standard. The board, however, is certainly able to inquire about the notice and make its own decision, not just whether it meets the bare standard, but whether it meets a standard that the board thinks is appropriate under the circumstances. My concern is fundamentally that the application says that it is for a side yard variance. That's essentially all that the notice tells those people who are within 200 feet, or of course, those people who may be beyond that, who read the notice that's published in the newspaper. There's nothing in the notice that indicates whether that side yard violation is, for example, a 6x8 shed in the back corner of the lot, which is a little too close to the property line, or a pool surround, perhaps, which is not an uncommon issue for this board, that's a little too close to a property line, or in this case, a substantial, what I interpret to be a 2.5 floor addition to the residence, which intrudes substantially into the side yard. So that's what my concern is. Again, my conclusion is it meets the fair standard, but the board is certainly entitled to go beyond that standard if it feels it's appropriate.
Patrick, have any of the neighbors come into the office and inquired about this so that they would understand that they would be familiar with what's being asked, what's going on?
Yes, Mr. Chairman, our office has fielded at least one that I know of, possibly two inquiries about this application.
Okay, and one of them was next to a neighbor, maybe?
I believe one was, yes.
Okay. So I'll throw this out to the board. Do you see any reason not to take this tonight with the, with the notice?
If I may,
Go ahead.
may I? Okay, thank you. Thank you for your comments, Mr. Anderson. And as you noted, it does meet the standard. We do have, with respect to the content of the notice, it has the date, time, place of the hearing. It also has the nature of the matters to be considered. Specifically in our notice, we state that the applicant proposes to continue to use the property for residential purposes with an addition for their growing family. We also meet the rest of the standards as far as the identification of the property. And particularly, we've specifically said that it's a C variance for the right side yard setback. I'm not sure if that's that specific neighbor, but again, as a board attorney has just stated, we do meet the standard for proper notice. So I would submit to the board that this application is absolutely ready to be heard and considered by the board.
Excuse me, Ms. Lilly, for the record, can
Yes.
you please introduce yourself to the board?
I'm sorry, this is Lisa Liley, and I am here on behalf of Vella, Singer, and Kleiner on behalf of the Bradleys.
Thank you.
Frank, I would say, let's move forward with it tonight.
I agree.
I agree.
Okay. Those in favor?
Aye.
Okay, let's go.
Thank you all.
No, you have the floor.
Thank you. So board members, with that being said, tonight we're here on behalf of the Bradleys. And they are the owners of block 161 and it's lot 4 in the CR zone. And that's commonly known as 108 Meadowbrook Drive. They are tonight seeking a bulk variance for a right yard setback as they propose to continue to use the property for residential purposes with an addition for the growing family as set forth in their notice. Tonight we'll present testimony by the Bradley's engineer as to C variances, including how the benefits of granting the variance outweigh the detriments of non-compliance with the zoning requirements. And testimony will also be presented by the Bradley's architect concerning the design of the project. With that being said, unless the board would like to start differently, I would like to bring forward our architect, Dan Fortunato. Unless the board would like to proceed differently.
No, let's go right ahead.
Excuse me,
Okay.
this is Fred
Oh.
Kinsler. Mr. Fortunato, do you want me to show any slides? If you do, please let me know. I'll share the screen so everybody can see what you're talking about. It'll probably be a little bit easier.
Do you have the floor plans that you can share?
I do. Do you have a PowerPoint or something that you were going to go?
I do not. We could probably just walk through it.
Okay, so
if you could-
I'll share the screen and you can tell me. Let me see. Let me get to that one.
Drawing A1 to start.
Okay, we need to have,
Yes, Mr. Herbert, I was going there. Yes, yes. Mr. Fortunato, can you please state for the board your educational background, please?
let's swear them in first, right?
Okay.
Mr. Fortunato, can you raise your hand, please? Your right hand? I can't see you. Oh, there you are. Do you solemnly swear the testimony you're about to give the board will be the truth, the whole truth, and nothing but the truth?
Yes, it will.
Please state your name and spell your last for the record.
Daniel Fortunato, and it's Fortunato.
Thank you.
Okay.
Thank you.
On the project, when we
We need
start,
Mr. Fortunato?
yes,
we need qualification first.
Yes, we were going to do the educational background for a moment. Mr. Fortunato, for the board's reference, we need to swear and have you recognized as an expert in this field. Can you please give the board the benefit of your educational background?
Yes, I have a Bachelor's of Industrial Design from Ohio State University and a Bachelor's in Architecture from Drexel University. Licensed in New York, New Jersey, Pennsylvania, and have appeared in front of this board several times.
Thank you, Mr. Fortunato. At this time, I would ask that the board accepts Mr. Fortunato as an expert in the field of architecture.
We can. Go ahead. We can.
Thank you.
Okay, thank you. When the Bradleys approached me about doing this project, we knew a variance would be required and we knew this going into the project, but basically the needs of the house far outweighs what they really needed to provide here. The house is a bit of a salt box style home. So even though it is a two-story, the entire back half of the house is unusable as a second floor because the roof slopes basically from the second floor right down to the first floor. So essentially only the front half of the house can be used as for a second floor. Basically looking at the floor plans, I'm sorry, slide A1, that's the original survey there. Thank you. So on the floor plan, obviously the right side where the addition is the gray walls, we needed to achieve a larger home for them since they are a growing family. They do have a newborn, and the master bedroom on the second floor with the master bath suite and so on is really the best option that you can really achieve with this house. Of course, a garage is needed, so we opted for the 2-car garage, and that would accommodate, of course, the second floor, which would be the master bedroom, home office, and the bathroom. And then that's essentially the part that is in a violation or encroachment for the setbacks. The rear part of the house, which is not in violation, is a extension for their home, again, a dining room and a mudroom coming off of the garage. Basically, the rest of the house will remain as is. They have a living room and a dining room and first floor playroom. And of course, the bedrooms will be on the second floor, basically making this a 4-bedroom home. If you can go to slide 2, I'm sorry, the drawing A2, thank you. So as you can see, the left side of the house, which is existing, is a lot lower, again, just based on the salt box style construction of the house. And the right side will be the 2-car garage with master bedroom suite above. And try to make it look as much in the vernacular of the neighborhood, not too loud, and it works very well for their needs. So essentially, this is the project that we need to have the board take a look at and see if we can move forward with this project.
It's John Stamler, Mr. Fortunato. I have a question.
Yes.
Obviously, adding on to the right side, of course, with a new family member. Another option is adding on to the back. So that was never mentioned, right? There's always an option to add to that back to take the slope out. But my question is this, with that addition that's going to the right, I see a 2-car garage. I don't see any diagram of where the existing driveway is. I'm assuming now the driveway is going to be doubled.
It's on drawing A1. If you could please go back to that slide. The upper right-hand corner, if you could zoom into the site survey, upper right-hand corner, you'll see the driveway indicated on the right. It's a little faint, but you can see it there. The curb cut and the driveway is there. There's a little bit of a dark gray sliver. That's essentially just showing the extension of the driveway to meet up with the 2-car, but they do have a driveway to nowhere, basically no garage there.
Right. Now, what's the, I'm looking at the neighbor's house next door and going over what's required. How close to the other dwelling is that addition now? Because now you're adding the addition, the driveway, and I'm looking at a satellite view and it's pretty tight with that other house, right? So what's the distance between, with the new addition and driveway, what's the distance between the two dwellings?
I do not have that information.
Does our engineer calculate that?
I do not have that dimension. The plans don't show the location of the house on the adjacent property.
Yeah, and that's what's disturbing to me, that we're not showing that other neighbor's house with these plans, and it's pretty tight when I look at the satellite view. All right, thank you.
Any other questions from board members? I had a couple of questions myself. First of all, this house never had a garage, did it?
No, it does not, did not.
Yes, this has to be one of the few in Hillsborough post-World War II that didn't. I think there's maybe one other. The other thing, I noticed down the block, about 3 or 4 houses down, there was another house that looked like it might have had the same situation where they made an addition, which then brought the house close to the property line to the house next door. Are you familiar with that house? Okay. I guess not, right?
Is there a question?
Yeah, I'm just saying, is this the only house like this on the block that's going to be in this condition? Or is there another one that's sort of like the same thing? If you don't know, just tell me you don't know.
Well, there are the 2-car garage structures on the property, on the block. This is the only one, like I said, probably the only one without a garage currently.
Okay, and that driveway was probably always there, if I got it from the curb cut.
That's correct. The driveway always was there. We're still maintaining the same driveway, same curb cut. We're just going to widen it just a little bit to accommodate the 2nd-car garage.
Well, I think there's a house 1 or 2 over without a garage, just to let you know.
Yeah, there was at least one other on the block, but I think 3 or 4 houses down to the
Yeah,
left.
Frank, I don't know what your point is, Frank. Yes, there's houses I could see with the garages, correct. But there's some without.
Any other questions from other board members?
This is Phil Solili. I hear what John is saying, and I think I share that same concern. Not knowing the distance between the 2 driveways and the property, I'm not going to say adjoining next to it, but close to it, I would think that we would need to have that information.
This is Tom Neff here. Don't quote me on these dimensions, but I'm just looking on Google Earth and using their built-in measurement tools. And it looks like the adjacent house on the side of the proposed addition is about 55 feet between that adjacent house and the current edge of the house. So question for the architect then, how wide is the addition you're proposing?
24 feet.
So it looks like it'd be about 31 feet. If these measurements are accurate, there'd be about 31 feet between the proposed addition and the adjacent house.
Has the property owner of that adjacent house made aware of this, and do they have any concerns?
Well, if I may, if the dimensions you're stating from Google Earth, we have a 14-foot 4-inch dimension we're proposing right now to the property line. And if the other, I mean, again, the setbacks are basically 25, it's supposed to be 25 feet in this area.
Right.
So I'm not sure if that means the house is 25, the one next door you're questioning could be further than the 17 feet you're stating.
Right.
Setback's supposed to be 25 feet. That's,
Well, how about this? You see that back fence? With the addition that's being added, is it even with that back fence? Or is it less than where that back fence protrudes out?
Excuse me, this is Fred Kinsler. I just want to make sure, can everybody see on the screen the lots? Or do you still see the architectural drawings?
Still look seeing the architectural drawing.
Architectural drawings.
All right, hold on one
Architectural.
second.
Okay.
I'm gonna
I'm
share
just wondering
this.
with the
So
addition.
now can you see the lots?
That's
Yeah.
much better, yeah.
Yes.
Okay, so sorry about that. I'm sorry to interject, but I figured this might be helpful for what you guys
No,
are
that's
talking.
okay. Thank you.
Yep.
Very helpful.
Which one are we looking at? Lot what?
Lot 4 is the proposed building lot.
Okay,
We're lot 4.
okay.
well, looking at the way it is right now, lot 5 is a lot closer than, it's gotta be closer to 25 feet, as well as lot 3. Again, they're probably closer than 25 feet on their side yard as well. Just eyeball on it here, and lot 6 just as well as, so they're all pretty close. Lot 6 and 5 Right, gives you a closest example by what we're gonna have here between lots 4 and 3.
I agree. That visual that you have up now is very helpful.
Sorry, I tried to get it up earlier. I wasn't sure. I didn't want to interrupt.
Yeah, that, right, that's an old photo, right? I don't even see the fence. I don't even see the driveway.
I think the driveways are probably under the trees. I don't know.
Right.
Hey, Fred, it's Patrick. For the record, what is this we're looking at the moment?
Sure, this is the document that was provided under the Bradley application. I believe it's called photos or the aerial plan.
Yes,
But
aerial plan.
It was the aerial plan that's in Civic Clerk, and also, Eva sent this to me as part of what was going to be presented.
Okay, I just wanted to announce for the record purposes.
Absolutely.
Thank you.
Hey, Patrick, lot 3, he looks like he's close to the property line. Does he have a variance for that addition?
I mean, with these things with the aerials, I mean, it looks close, but depending on the angle of the Sally, when sometimes these things are done, things are a lot farther, but I can see what you're saying.
Yeah, John, my impression when I went out there was that the house on lot 3 probably was like this one at one time, and they added a garage on, which brought it closer to that property line.
Well, that's obvious. They added it on. Did they?
No, I didn't say that. It might have been original, but maybe not. I don't know. You can't tell.
Right.
But
No, my concern was with the new addition. When I look at the street view and I see that fence, I'm just wondering now with the addition, how close in proximity to that back fence along the border, because I'm just trying to figure out how close. Well, I don't know, maybe that neighbor's here, I'm not too sure, but that was my only question, because with the addition, it's close to that other one. That's all. Thank you.
any more board member questions? If not, I'll ask for a motion to open public.
I have a question. Was there any, I used to actually live in this neighborhood, and I do know the lots are a nice size, but was there any consideration given to doing a drawing that would have gone to the back of the house to alleviate the need for the variance? And I understand you're doing it over a garage, but if was there any thought to doing it out the back instead?
No, only because the second floor was very difficult to work with. If this was a standard 2-story colonial, we could probably do something like that. But since the whole front of the half of the house is where the bedrooms are, we couldn't really get a bridge, if you will, from there all the way over to the back of the house to accommodate this. So we're just trying to keep the bedrooms in line towards the front of the house.
Well, not only that, but as you stated earlier, the roof slopes down pretty severely towards the back of the house. I don't know if that
Right.
makes
Yeah.
it much more difficult to add on.
No, I remember the model, so. Yeah.
Any more questions from the board members?
No.
Hearing none, motion to open public.
So moved.
Second,
Those in favor?
aye.
Okay. At this point, we'll open the lines for public questioning of this witness. At this point, you have an opportunity to question this witness on his testimony. And at the end, if you have comments, you'll have another opportunity to make comments. But at this point, it's just a question this witness. So Fred, would you open the lines for the questioning?
Sure. If anybody from the public has a question for this witness on this application, please raise your hand. Okay, I see one. Please state your name. Ms. Smith, could you please unmute yourself, state your name and address for the record? We can't hear you, Mr. Smith. Mr. Smith, you're still muted. There you go. Could you please state your name and address for the record, please?
106 Meadowbrook Drive, Walter Ivas, I-V-A-S.
Thank you.
Do you have questions for this witness? Sir?
The architect.
Yes, I have, the question is on, when we go back to water, water has been a problem from the time this thing was built. And if you look at history of what had to be done, that this wasn't a swamp, which it was before it was done. And when storm sewers were never put in. Now, right now, we have a storm whole back of our yard.
Chairman, if I may, the witness,
Okay, yeah.
speaker appears to be making a statement.
Right.
It's important that all speakers recognize that if they're making statements now, they will not be taken into consideration by the board. Your opportunity to make a statement will come later. So now you need to confine yourself to questions for the witness.
So, sir, do you have any questions? Do you have any questions for the architect from his testimony?
Yes.
Okay.
Yeah. I'd like to know how close, I'm looking at that, it would be like the only space between my property and their property will be a sidewalk. That'd be about the space between it, like living in a city where you have a driveway, a walkway between you and a neighbor.
Now, what's the question?
That it would be so close. That would be just like they have to put a drive.
Okay. So again, you make
I'm having a hard time.
Okay.
If
At this point, again, do you have a question for the witness? Because you're going to get an opportunity later on.
Well, that's the architect. I want to ask them, how come they built so close that it's only the width of a driveway, not driveway, but a walkway between the properties?
Well, the property line is to the addition is 14 feet. It's shown on the drawing on the site survey, 14
feet encroachment.
What was that
14
again?
feet encroachment in the side yard.
How much what I'm asking you now is, how much property is actually being
Well,
moved?
there's a 14 feet encroachment.
Encroachment, how much is actually being encroached? And how much difference will there be between our property line and the encroachment line?
Well, the addition itself is 24 feet from the existing house, which leaves 14 feet, 4 inches of green space between the property line and the addition.
So the answer is 14 feet.
Opposite, there's a right of way there with the storm source.
We're not encroaching in the right of way.
Why aren't you, when you're going up there, that's still part of the money, the property you're taking away?
No.
No, we're not encroaching into the easement.
Okay.
It's not going that
It's
far.
from there.
It's not going that far.
It's from,
Okay.
it's 11 feet.
Mr. Chairman, we appear to have more than one person speaking. At this point, we should only have the questioner and the witness.
Okay, do you have any more questions, sir, for this witness?
Right now, I don't have anything.
Okay, and again, at the end, you'll get a chance to, give your, to tell us what you think, what's on your mind about this, okay?
Hey, Frank, it's John Stamler. I just want to just ask, what, was Mr. Smith's question answered? He wanted to know how many feet was that addition to his property line?
Okay, from the
And somebody
building,
said 14 feet? Was that the
Yes.
answer?
It sounded like his question was, the addition is going 24 feet from the existing house towards the property line. And then there's left 14 foot 4 inches of green space between the addition and the property line.
Are you happy with that?
I got from the question.
Does that answer your question, mister?
What's that? Does that answer your question?
Mr. Smith, are you fine with that answer?
I don't know. Yes.
Okay.
Yes.
Let's move on. Is there any other members of the public that have questions for this witness? Hearing none, Fred, you can close the lines.
Okay.
Okay.
You're all set, Frank. Go ahead.
Okay, additional testimony or?
Yes, I'd like to speak with our other professional, Wayne Ingram.
Hello.
Hi, Wayne. How are you?
Good.
Good, good. I think we need to swear Mr. Ingram in.
Yes.
Ingram, can you raise your hand, please? Do you solemnly swear testimony you're about to give this board will be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name, spell your last for the record?
Wayne Ingram, INGRAM.
Thank you.
Good evening, Wayne. How are you?
Good.
Good. Could you please give the board the benefit of your educational background?
Sure. I'm a licensed engineer and planner. I've been a licensed engineer for 10 years and a licensed planner for approximately 8. I've appeared before over 50, 60 municipalities in both of those capacities, including Hillsborough Township.
Okay, we can accept his qualifications.
Thank you.
Thank you. Mr. Ingram, can you, given the previous testimony you've heard and your understanding of the application, can you please describe the C variance that is sought for the property,
Sure.
including but not limited to how that variance can be granted without any substantial detriment to the public good and without substantial impairment to the intent and purpose of the zoning plan and zoning ordinance?
Yes.
Thank you.
As you've heard, the request is to reduce the 25-foot side yard setback to 14.3 feet. No other variances are required by the application. The property, the home itself is one of the smaller footprint homes in the neighborhood. It's a mixed neighborhood of 2-story and single-story homes. But again, I would say footprint-wise, this is one of the smallest and one of very few that doesn't have a garage to it. The current side yard setbacks are 30.9 and 38.6 feet. The lot has an existing width of 103.8 feet, where the zone typically requires 120. So many of the homes in the neighborhood have the same deficit in lot width, which certainly makes it more difficult to comply with a 25-foot setback, especially on a property like this, where the home is located basically in the center of that lot with a substandard width. It's impossible in either direction, really, to install a 2-car garage in a conforming fashion, as many of the other houses have. Based on my review of the surrounding area, many of the homes, some of which you've already seen, have a substandard setback of the side yard. I measured the side yard setback of the neighboring lot 3 at about 13 feet. Lots 5 and 6 next door on the other side have 15-foot setbacks on one side. You go further down the street, it's again pretty consistent that almost every home has at least one side yard setback in some sort of a deficit. So this is not an uncommon condition to the neighborhood. The owners are wishing to enlarge their home to provide a more suitable space for their family. If we were to comply, we would only be allowed a 13-foot addition, which could again be only a 1-car garage and wouldn't adequately provide for a master bedroom, which is somewhat lacking to this home. It would not make sense to try enlargement on the opposite side, as we would have essentially the same issue. Not to mention, we would then have to demolish an existing driveway, move it to the opposite side of the property, which is somewhat of a waste for the resources out there. To try and split the addition, really wouldn't make sense either. It would cause such devastation to the home, that it would not be a viable option. So, in order to comply and as much as possible, and have a two-car garage, which again, I would say is fairly typical to the neighborhood and desirable for most homes these days in this area, would not be one that we could accomplish in a better scenario. You also heard from the architect how trying to reconfigure it to the rear would not work in this particular instance based on the configuration of the home. Would also require a lot more impervious surface and basically take away any windows of the rear of the house. None of these in my mind would desire from the property.
Mr. Ingram? Oh, am I the only one who lost him?
He blipped a little, but I think he might be back.
Okay.
Sorry, I'm not sure where I left off.
About 3 sentences before.
Yep, it was right at the end.
Okay. So I was just saying, I don't believe that there was a configuration, a preferable configuration over what you have here. Certainly, providing for a garage that allows vehicles to be stored inside reduces clutter outside the home, which would be visible from the street. And having this garage will eliminate that, which I think will be a desirable aspect to the neighborhood, as well as just modernizing the home in general. And because of the configuration, we don't have another way really to accomplish that without seeking some sort of a variance condition. I think what was testified earlier with regard to there being roughly a 30-foot setback, if this were to be constructed between the homes, is about accurate. And again, that's also a deviation that currently exists on the neighboring lot. Also, that is their garage as well. So the garages basically would meet up to one another. So, it's not as if the addition would be one that influences views out of a neighboring home because it's their garage. It's not their windows that they're looking into their yard or the surrounding area. I believe that this is a proposal that fits into the character of the neighborhood. It'll make the home more in line with the surrounding structures. Again, many of which have that similar deviations and setbacks. I think we're supporting purpose I, providing a desirable visual environment. We'll be beautifying, updating the home, providing a garage that will allow vehicles and other things that would normally be left outside if you don't have a garage inside, which certainly improves the ability to not have things stored outside which detract from the visual environment. I don't really see any negative impacts from the granting of the application. Again, this isn't something that I think would stand out in the neighborhood given the many other deviations in side yards. It'll be placed adjacent to that garage, so they're not going to look out their windows really and see this. It's just looking out it's a garage, not a part of the main home in which the neighbors would live. I don't see any conflicts really with the master plan or the zoning plan. It's a fairly innocuous application with that really complies with all the other intents of the zoning ordinance. Clearly, I think we're asking for a flexible C variance, not necessarily a hardship. But I think in that vein, I believe that is simply because doing this in the fashion we are is more beneficial. It's a preferred orientation to any other way we could attempt to provide two-car garage to this property, again, which is a feature I think is common to the neighborhood and a desirable thing that most homeowners would desire and look for in a lot. It'll certainly be one of the, I'd say one of the nicer homes on the development if this application were to proceed. So
Frank?
I feel that the positives outweigh the negatives of the application to support the granting of the variance.
Okay.
Frank, I have one question. Sir, you kept saying it's only a garage, but the second floor is going to be the master bedroom. So it's more than just merely a garage that would be overlooking the adjacent property. Isn't that correct?
Yes, that's from our property. What I meant was the neighbor whose setback would be reduced in essence has a single story home with their garage facing this addition. So it's not, when they look at their windows, they're not seeing the addition. If our client wants to look out their windows in this fashion, that's what they're choosing with the application.
Okay, I'm sorry, I misunderstood then.
Any other questions from the board members?
Hi, this is Tom Neff. For the engineer, can you just provide any comments on the existing topography of the site? Do you anticipate that by building this addition, you'll have to do any grading or drainage changes to the property?
I don't foresee any major changes to the grade of the property. Looking at it, I was primarily brought on to be a planner for the application, but in looking at the property from the street, it's a fairly level area. It's off to the side of the house. The existing driveway is going to come right up to it. So, there's no changes to drainage I would foresee with this application.
Okay. Anything, a plot plan would be required for the building permit, so I have no other questions. Thank you.
Okay, I gather from one of the neighbors that they were concerned about the wetness of the property. Can you address that? Is there a problem now, or is it this going to change it?
I'm sorry, I didn't hear the beginning of your question.
Okay, so I gather from the question from the neighbor that they're concerned about the drainage of the property. It may be wet out there. Are you familiar with the composition of the property right now? Is water a problem, or is this going to change anything or make it better or worse?
I mean, there appears to be a swale between the properties, which is located within the easement that exists between the lots. We're not encroaching on that easement. There would have to be no regrading of anything in that easement to accommodate the addition. The property is maintained lawn where everything's being accomplished. So, there's no obvious, issue with water. First floor, it's not as if we're building a basement that we have to worry about, subsurface water or anything being a concern for a bit, basement here. Basically be an at-grade, improvement. So again, I don't see any change to the drainage, and especially because this is meeting up to the garage, the slope of the driveway just goes out to the street. So that water is just going to be directed out to the road and not at an adjacent residence.
Okay. And at this point, we'll open up for questions from the public for this witness.
Okay, anyone from the public have a question, simply a question for this witness, no statements. That'll be another time. So anybody have a question for this witness, please raise your hand. Again, I ask you to state your name and address for the record. Seeing none, Chairman, I think you could proceed.
Okay, so Tom, any questions of you about, engineering questions or issues or?
No, I think everything's been discussed, without having the benefit of a detailed existing grading plan or proposed grading plan. But just looking at the property, it does appear to be relatively flat where the addition is proposed. So I don't anticipate that the proposed addition would have any negative impacts. Again, that would be confirmed when a plot plan is submitted at a later date.
Hey, Patrick, anything from you from a zoning viewpoint?
Yes, I just want to touch on one of the points from Mr. Ingram's testimony where he stated that the property has a non-conforming frontage. The CR zone is required to have a 125-foot frontage. Essentially, this property has 103. The neighborhood itself, it goes back quite a ways. It's known as Amwell Estates. There's quite a few properties in this development that do have non-conforming frontages. And that's all I have to add at this point for the board's knowledge.
And Mark, do you have anything to add?
Nothing at this point, Mr. Chairman. Thank you.
Okay, I guess at this point, then we'll open it for public comment. At this point, anybody in the public that wants to make a statement about this, this is your opportunity.
Mr. Chairman.
Okay, so again, at this point, anybody from the, sorry, Mr. Anderson, go ahead.
Thank you. It'd be appropriate to remind people that want to make statements that those have to be under oath.
Right, you will be asked to be under oath, right? Go ahead, Fred.
Anybody from the public wants to make a comment on this application, now is your time. Again, please state your name and address, and you'll be asked to speak under oath. All right. Okay, so please, there you go. Can you state your name and address?
Walter Ivas, Ivas, 106 Meadow Drive. The only thing I have to say is.
Mr. Ibis,
Hold
can
on,
you
Mr.
raise,
Ibis.
can you just raise, I'm gonna
the
swear you
water flow.
in.
If you look at their property.
Mr. Ibis, please, you have to be sworn in.
Oh, okay.
Go ahead.
Do you solemnly swear the testimony you're going to give this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead.
The only question I have, the big question I have is about the natural flow of drainage. If you look at that piece of property, the back left corner is about at least 6 feet higher than the front of the house. And it goes towards 106 at another angle where it's about 4 feet higher. Now, in that corner of 106 is a storm drain. I don't know if you know that. And the right of way goes right away all the way over to 104, which their right corner has a storm sewer. Because we were draining through this area, all the water coming even off of Route 206 until they put the new storm sewers in. We would have, anytime it rained, you would have water pouring in your cellar windows. But this was probably one of the low spots where I'm not sure what was there before, whether it was a stream running through there or what. But it was the lowest spot going through. If you looked at the area, it would be any rain that would come up on their property, it was going to come towards 106. And what happens is with the new amount of housing in there, that water is not going to go straight down to the road there. It's going to come over towards 106. It's going to follow the back of the house and end up going towards the property. And hopefully, if this goes through, that I don't have to have water, a problem with water coming because it's coming down off of the property. I'm not on a natural flow.
I see a word that this is going to push water on from their property onto yours. Is that right?
Yes.
Okay. And I think we just heard from the
The
engineer.
natural drainage I'm worried about.
The drainage, right? And I guess to answer your question, I think we already had testimony. Well, Mr. Neff, the engineer, said that there's a swale there, and this should not do that. Would you want to comment on that, Tom?
I was just going to say that, this property, I think it benefits the property that there is this existing swale and the drainage easement and the inlets nearby. So if by some chance something does happen, it should be relatively easy enough to fix any drainage issues because they are lucky enough to have this swale and inlet nearby. So perhaps we could just get the applicant or the applicant's engineer or counsel to agree that they would address any negative impacts to the adjacent properties if they were to develop as part of this application.
That's a good suggestion. I think the question from the public, maybe he would like that on record, that the engineer ensures the proper drainage is done. Okay, Frank, is that possible?
It sounds like it's a condition to be, right? Sounds like it would be conditioned for approval. John?
Yep, we could put that as a condition.
Okay.
Thank you.
Okay, you're welcome. Anybody else from the public that has a comment? Fred?
Seeing none, Chairman, you can proceed.
Okay. So at this point, we'll motion to close public.
Motion to close.
Second.
Second.
Those in favor?
Aye.
A public close. Board discussion?
What was that, Frank?
Well, board discussion at this point about the application.
I think it's a good application. I just want to make sure we I'll do the motion, but I'll add that condition to ensure the neighbor, with his concerns about the proper drainage, because I have a swale on both sides of my property too. Heavy, downpours and storms, it's like a river. So I understand his concern because there is a lot of grass that's absorbing a lot of water off that existing dwelling. So I'll add that to my, to the, add it as a condition that our engineer checks it all out and ensures that the neighbor is maybe notified that it was validated. Okay, Frank?
Sounds good.
Hey, Frank, it's Jim. I didn't see it in the plan, and maybe it's a question for the architect, but what is proposed for the water coming off the roof of the new addition? Is it going to any sort of underground drainage, or is it just being, shot out at grade level?
No, the intent is to have it just go to splash blocks at grade.
Okay.
And we would direct those towards the front of the property or towards the swale. They won't be, directed in a negative way. And that'll be part of any plot plan that's required.
Okay. Anybody else on the board have any comment there? Okay, hearing none, do I hear a motion?
I'll motion to approve this application with the condition that our engineer and engineering department just validates and just verifies that there's proper drainage to ensure that the neighbor on 106 is satisfied. And that's the only.
I'll second that motion.
Okay, roll call, Tina?
Yes. Okay, Mr. Stamler,
Yes.
Ms. Haynes,
Yes.
Mr. Sirachi,
Yes.
Ms. Salili,
Yes.
Mr. Alcheck,
Yes.
Ms. Erickson,
Yes.
and then Chairman Herbert, right? That's all I need?
Yes. I need 7, right? Okay.
Yep.
And so 7 yes, no no's, so good luck with your application.
Yes, good luck.
Thank you.
Thank you very much.
Congratulations.
Thank you so much.
Thank you.
Thank you for your
Thank
time.
you.
I'm sure it'll
Have a
look
good
good.
night. Thank you very much.
Bye-bye.
Fred, do you want to set it up for the next, is everybody on for the next one? Next
Yes.
motion? The next
Yes,
up?
they are, Chairman.
Just let me clear my desk here.
I'm gonna call them real quick.
Hey, Patrick. Next and last application this evening is Christian Community Chapel, file BA 16-10, amended site plan. Patrick, would you introduce us, please?
Yes, next application tonight, as stated by the chairman, it's for Christian Community Chapel for an amended BA 1610, located at block 147, lot 20.01, otherwise known as 121 South Branch Road. Applicant is seeking an amended preliminary and final site plan approval, a D1 use variance and D6 variance on the property in the ROS zoning district. All yours, or if you want me to elaborate a little bit more about this application, Mr. Chairman.
I'm sorry.
Do you want me to elaborate for the board a little bit more about this application at the moment?
And Mark may want to add some comments too.
Sure. Mark, do you want me to start or you?
Mr. Gorman, why don't you start?
Sure thing. So if the board recalls, this particular application has some history before the board. They were before the board, it says 16 application, but they were last before the board in 2017 for a site approval. Prior to this application, there was a settlement between the township and the applicant for the use variance, which outlined a bunch of conditions as part of that settlement for the board to follow. The board subsequently adopted that settlement as part of their site plan approval back in 2017. They're before the board tonight to amend the application for the site plan in a couple of different ways. One is that they're asking for a waiver to not pave the main parking lot, but to use a gravel surface instead, which is not approved as part of the prior site plan approval. The variances are involved. It's a little more, it looks a little more involved than it may be. The settlement originally gave the applicant a use variance per se. They're here tonight because they are deviating from at least one of those conditions as part of the settlement. And essentially, the only method that they're here tonight for is to request a new D variance, because essentially they're going away from the original settlement and they're asking for something new. And Mark will go over that in a little bit more detail. As part of that, and how it's outlined and set up in the settlement, is that the variances are all in one section. So let's say it was number 1A was for the use variance to use the house of worship with the parsonage, and a D6 variance for the height, and that's for the silo. I just want to bring to the board that the D6 variance, as part of this application, that there's no change in the height of the silo, but it's a technicality that the board has to reaffirm or reapprove because everything was in that one subsection of the court settlement. I'm happy to answer any questions you have at this time. As Mark gives any more detail, please follow up.
Mr. Chairman, Mr. Gorman, as usual, I think was very complete. A couple of things that I would emphasize that he said. Of course, I think the board is fully aware that this was the subject of a lawsuit in 2016, which was resolved without trial. That is by agreement between the parties. The only things that were specifically approved in that settlement were the variances. There was no site plan approval as a part of that. The settlement actually specifically required that the plaintiff obtain major site plan approval. And that's, of course, one of the requests that the applicant is now making. But the primary things that were agreed to before were a use variance permitting a dual use, specifically the existing residence, plus use of the property as a place of worship, and bulk variances, in particular the existing 45-foot silo that exceeds the 35-foot maximum. Mr. Gorman is correct that I would put it perhaps a little differently, that in the settlement, what has been agreed to for variances is not separated by condition work. Maybe I should put it the other way around. The conditions are not specific to the individual variance items. So we have a list of conditions which appear to apply to everything. And some of those conditions, as Mr. Gorman has indicated, are inconsistent with what was agreed to in the settlement. So the issues before you are the variances, as Mr. Gorman has indicated, and major site plan approval. Major site plan approval, of course, includes all of those things that are usually part of site plan. In this case, fire safety was certainly previously a major issue, and fire safety continues to be an appropriate area of inquiry for the board in considering this major site plan.
Mr. Chairman, Pat Gorman speaking. I was looking to get the fire marshal on here. I'm looking to see if I have a response yet. So if I can request a brief pause.
Yes. Okay, so why don't we take 10 minutes? Everybody put yourself on mute. Is 10 minutes enough or 5 minutes?
5 minutes should be suffice.
5 minutes. It's okay. So we're back at 8:20.
Hello, this is Fred Kinsler, the IT. Is the fire marshal on now? Can you speak so we can hear you?
Yes, this is Chris Winiger. I'm the fire marshal.
Hi, Chris. How are you? It's Fred Kinsler, IT at
Okay.
Hillsborough. How are you doing?
Okay.
I assume when the meeting starts, I assume Tina will record your presence and ask you, some information so we can note that you joined the meeting at 8:20. Okay.
Yes, sir.
I'll leave you unmuted so you can speak as needed. Patrick, he is on.
Great.
Chairman Herbert, the fire marshal Frank Winiger is on.
He has a 732 number.
That is correct. And I assume Tina can note his presence at 8:20.
Yeah, I'm sorry. What's the name again, sir?
First name is Chris. Last name is Winiger, Weniger.
I apologize because I'm sure in the past I spelled your last name wrong.
No problem. Lots of people do.
Thank you for your time, Chris.
No time, no problem.
It's 8:20. Is everybody back? I see a lot of people are still muted.
I'm here.
Okay.
I'm here.
That was Janine, sorry.
Okay. Jim, you're back?
Yes.
John? John Stemler?
He's muted, Frank.
Yeah. John, you're muted if you're back.
Frank Valchek back.
John must have taken the long 5-minute break.
No, that's the, and Kurt, you're back, right?
Yep, I'm here.
Frank's back, so everybody's back.
Adonis, you still with us, Adonis?
Yeah, we have 7 members. John, you're back, right? I assume. Okay, I think everybody's back, so,
Mr.
Tom?
Cheerful's back.
Tom, now if you're back,
yes. Okay, so we ready to proceed with the presentation?
Michael Grodnick.
Ready to go? So good
Go ahead.
Good evening, members of the board. My name is Mike Ogrodnik. I'm an attorney at Savo, Shaw, Gillespie, Ogrodnik, and Fisher in Somerville. I'm here on behalf of my applicant, Christian Community Chapel, which is operating as the Loft Wesleyan Church. We're seeking final amended major site plan approval necessary to convert an old barn into a house of worship on a farm that's located just at the end of South Branch Road, just before the intersection of River Road. It's a property. It's 14.34 acres. It's in the rural suburban zone. It's surrounded by farmland, surrounded by corn. There's an existing pool, existing 2-family structure, and some farm buildings. The intention of this application is to convert the beautiful old barn into a house of worship, an office, a kitchen, a fellowship hall. There's a building that was being used as an art studio that's intended to be used for youth instruction, Bible study, classrooms. This application proposes widening the driveway for a 2-way ingress and egress, as our engineer will explain the existing and the proposed details. This is an application that, again, as reiterated in the preamble, was ultimately approved via a preliminary and final site plan approval, which was memorialized on March 15th, 2017, which granted all of the variances that we're talking about. Again, that's the variance suggested that there's the parsonage plus the house of worship are two uses on one single lot, which is a D2 use variance, as well as the grain silo that's been existing for many years that exceeds the height standard, which is a D6 height variance. Those were approved as part of the most recent application before this board back in 2017. This application essentially seeks to scale back the project to reduce costs. It's, obviously very expensive to undertake converting an old barn into a modern commercial building for worship. So what we had done is we had suggested eliminating the parking area with paved area, which will reduce the impervious or improve the impervious for stormwater. And we had also, we've looked at some other minor changes to the plan. Since this application deviates from the prior approvals, the board has indicated that this would necessitate a D1 use variance. So again, eliminating the main cost saving and main change that we're proposing is eliminating the second floor of the barn to be used as additional space for the house of worship. So it would just be a one-story cathedral chapel hall. This was, I was just Googled it today, and this was of particular concern. I think the quote at the time in 2000 and the early 2015, 16 was they were afraid that this would be some type of fire hazard. So we think that we've obviously improved the fire with eliminating that second floor in this old barn. And of course, that provides some substantial cost savings. We are proposing to sprinkler the building after, although perhaps technically we don't, are not required to sprinkler the building. The applicant is certainly willing to undertake the substantial cost to sprinkler this structure. And I'll have Tom Decker from Van Cleef talk about all the fire issues. Again, the parking lot material was changed from asphalt to gravel. We would pave the 88 spaces. And there's just some minor changes to the secondary driveway access. In case of an emergency, there would be a slight adjustment to the location of the secondary access. And again,
it's John Stamler. Sorry to interrupt. Going back to the pavement and the gravel, are the schematics staying the same? The size of the parking lot? You just, I know you're saying you're still keeping some pavement, but you're converting it over to gravel now instead of pavement. But is everything staying the same? You're just doing gravel?
Yes, the only, and Tom Decker will get into the specific site plan changes, but yes, it's the same dimensions.
Mr. Granick, I'm sorry to interrupt you real quick, but I think we lost our court reporter.
Oh, okay, let's wait a second then.
I apologize.
No, I know it's recorded, but let's wait for her to get back.
You didn't know how far back we lost her, didn't you?
Yeah, I was just going through the participants from time to time just to make sure all the people that need to be here or anyone dropped off, so I can pause things intermittently if need be. This happened to be one of those times.
Did she come back after the break?
I believe she was back here for the break. We'll double check to make sure her audio was still functioning at the time.
Well, it's a good thing it's recorded because I don't think we want to repeat.
Maybe she's watching on YouTube right now.
We got backup for the backup.
I'm going to go check on the stream and see if I can tell when she dropped off.
Okay.
This is.
And Patrick, were you gonna call her or?
Yeah, she's popped back on. Yeah. I have everyone's number here just in case this happens.
Okay, that's Tina.
Okay, Tina, are you back on? Can you unmute?
Yep, sorry guys, I lost you.
How
Okay,
long?
can you hear me?
Yeah. have any idea how much you missed or?
Okay, yeah, I know where I was. I was on the sprinklers. I remember that. Okay, technically, we're not required to sprinkler the building. The applicant. Mike, you know. where
Okay,
you are?
the applicant does intend to sprinkler the building, which includes various water tanks, 15,000 gallons for the sprinkler system, as well as a reserve tank. Again, Tom Decker will detail all the site plan issues. The impervious coverage is slightly decreased. It goes from 10.43% to 10.18%. Certain site improvements have already been done. The tennis court was eliminated. Part of the building was eliminated, which eliminates one of the side yard variances. So tonight, I just have two witnesses. I have Tom Decker from Van Cleef Engineering Associates. He's going to, he's been with this project from the beginning. I wasn't, and he's going to explain basically the difference between what was agreed to and approved as part of the 2017 approvals. And then I have, I did bring in Art Bernard, who's a professional planner, who would just go over the necessary standards for these proposed changes. So both of these witnesses I know appear regularly. I personally have introduced them regularly before this board. So I would ask that Tom Decker be submitted as our professional civil engineer and Art Bernard as our professional planner. I do have our architect here. There's no architectural changes. I encourage you to look at the architecture. I think it's, an interesting building and a beautiful building. And we also have Pastor Nash, who can answer any operational questions. How many people are in his congregation? How many, what are the hours of his services? It's your typical church kind of off hours services. So,
Hey, Michael, it's John Stamler again. I'm a simple man, and I know we're going to hear some other folks testify, but there must be a nice summary or a nice short bullet list of what deviates from the original agreement, right? How many items are we talking about? And can you just bullet them for me so I can have a checklist?
Sure. So number one, the second floor of the barn is eliminated, and the sanctuary will be located at the ground level.
Okay.
2, the parking lot material was changed from asphalt to gravel, with the exception of the ADA compliant parking spaces. 3, a gravel driveway detail was provided. I'm not sure what that means. We'll have to ask Tom about that. The secondary access driveway was revised, and the grading was revised. The impervious coverages are reduced, so I'm not sure that's relevant, from 10.43% to 10.18%. So those are the 4 deviations, but I'll have Tom Decker just go over the existing features plan as well as the proposed.
No,
Mike,
that's
I'm sorry.
no,
John?
that's great. Yeah, the 3 are the most important. The park and pavement. Yep, got them. Thank you, Michael.
Mike, and I have a question, and Mark, can we stipulate that, what Pastor Nash had testified before and what was agreed to, the hours of operation and the various church activities and all those things, can't we stipulate as that they're staying the same, I'm assuming, rather than having the complete testimony all over again?
Yeah,
I think the answer is yes. There would be a difficulty, I think, in talking about the testimony itself, because that's reaching back to a different hearing. But the stipulations, I think they should be placed on the record again. But the stipulations, whether they were before or now or both, they can be placed on the record.
That's fine, and we're not going to attempt to revisit all those conditions that we agreed to. So I would ask that Tom Decker just go over the site plan and the changes.
Okay, Tina Swearman, we can accept this qualification. We're familiar with them.
Mr. Decker, can you raise your right hand? Do you solemnly swear testimony you're about to give this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Tom Decker.
Good evening. So as Mike had mentioned, for the most part, the original approved site plan has remained unchanged. Geometry, except for the emergency access, has stayed the same. And maybe the best thing for us to do is if we can pull up one of the exhibits.
Yes, Tom, which exhibit would you like? Is it one of the overviews, the aerials, or the greens?
If you could, well, let me see. I'm looking at the list that you have. Can you open up the one that says render 9/16/20?
Yes, let me get that one. 9 render 9/16/20. Okay, let me share that one. Just give me one sec. Share screen. That one?
Yes. Okay. Can we pan out to show the whole sheet?
Yep, let me get there. Does that look better?
Excellent, thank you.
You're welcome.
Pardon me, Tom, Pat Gorman here. Is this an exhibit or something we already received before?
This is an exhibit. Essentially, it's a colorized version of the site plan that was submitted.
Patrick, this is Fred. This is also from Civic Clerk. This has been submitted and is on the documents that everybody has access to.
Okay, just confirming.
Yep.
Okay.
So we don't have to mark it as evidence then, right?
Mr. Chairman, we of course have the question of what we do with exhibits with these Zoom meetings. I think that anything that's posted on Civic Clerk has already become a part of the record. And this particular drawing, I think, has been very specifically identified by Mr. Decker. So I don't think we can't physically mark it anyway, but I think it is sufficiently identified.
I'm marking on my screen here. Okay, good.
Yeah, but your grease pencil, not good for your screen.
Okay. It's hard for me to do this. I'm used to pointing to
If you want me to zoom in, Mr. Decker, just let me know.
Okay. So what's shown here is the proposed site layout as submitted. It is essentially the same as was submitted prior. You'll see in the at the bottom you have your access off of South Branch Road. The gray shading coming up is a widening of the existing driveway to a width of 25 feet. That comes up, continues up, and as you follow the cursor, straight ahead from where the cursor is where the barn is located. That will be converted. To the left of that is the parking area. And that parking area is no different than what was proposed earlier in the prior application. It has the same number of parking spaces, the same configuration. The only difference is that we're proposing a gravel surface for most of the lot with the ADA parking spaces closest to the building to remain as paved.
Hey, Tom, it's John Stamler. So the paved parking lots will have white lines and the gravel will just be gravel, correct?
Correct. The paved portion will be striped for ADA spaces, the striping in between, and then the rest of the lot will have wheel stops, which is consistent with what was proposed previously. There's no curb around the parking lot. There was none previously. We're really just changing the surface.
Tom, there's going to be only 2 ADA places, right? Parking places.
I believe there's actually 3.
All right, but that's the only part that's going to be paved.
Yeah, there's three, and then if you look there, in that paved area, the 3 ADA spaces are towards the top. There are 2 regular parking spaces that are also paved. And that was primarily because it was just easier to square off that area rather than, have just those paved spaces sticking out into the gravel. So there are two other regular spaces that are going to be paved.
Tom, the other thing is, how do you plow sufficiently for a group of people of all ages to come to worship, to come and attend other church activities? How do you say that it's going to be as safe as if it were macadamized and you can plow pretty much right down to the surface?
That is a very good question. Gravel parking lots they are plowed on a regular basis. You don't put the plow down all the way to the surface, otherwise you do end up scraping the stone to the end of the parking lot, and it has to be dressed up afterwards. Inevitably, you do get some stone that does get pushed, and then it has to be dressed up. It can be plowed. It would not be plowed as cleanly as a paved parking lot. With one of the reasons why we're proposing gravel, as Mr. Ogrodnik indicated before, is it's a cost item, but also unlike a retail parking lot, this parking lot will be used primarily on Sundays, days of worship, and otherwise during the rest of the week will essentially sit idle.
Well, we had testimony that there would be weddings, there would be other sorts of church meetings involved. So I don't know, you can say only Sunday. And I must remind the applicant that cost is not a concern, public safety is.
Understood. And I think I may have misspoke. What I meant by the parking lot not being used is that the parking lot in its total would not be used on you would still have meetings and so forth. Some of those meetings would be held in some of the other buildings that were indicated prior. The old art studio has become more of an office for small gatherings and so forth and meetings. So we are requesting the waiver for the gravel parking lot. And there were, under the original approval, there were waivers granted for the aisle width and parking space depth. The ordinance requires, I believe, 30-foot wide aisle. Waivers are granted for 25-foot, and parking spaces that had an overhang were allowed to be 20 feet deep rather than, we're allowed to be 18 feet deep rather than the 20 feet deep as required by the ordinance. With regards to the barn conversion, again, as was stated earlier, originally the proposal was to have the sanctuary on the second floor with a fellowship hall on the first. The church, in evaluating costs and so forth, has elected to now put the sanctuary on the first floor. There will not be a second floor. It will be essentially an open air or a cathedral type setting. And although we're on the first floor, we did meet with Mr. Winiger regarding fire safety. And while the building code doesn't require fire suppression in the building, Mr. Winiger had requested that as a safety issue, and we continue to propose that. The fire suppression will be served by a 15,000 gallon water tank, which will have to serve the fire suppression, and there will also be a 30,000 gallon capacity for the first responders to have a water supply on site to use, as there's no public water. Currently, and as was proposed previously, The water supply is provided in a single 45,000 gallon tank. So there's 30,000 gallons for the first responders and there's 15,000 gallons for the fire suppression. That tank can be partitioned to dedicate the 30,000 and the 15,000. We would ask that, obviously this would be subject to the building department's approval, but if we were to determine that it may be more cost effective to have a 30,000 gallon standalone tank for the first responders and a 15,000 gallon tank for the fire suppression, that we have that flexibility. In either case, it's going to be 45,000 gallons as requested by the fire official. Let's see, as was indicated previously, and while we're zoomed in here, you'll see at the top, there's a notation for an existing farm structure to remain, and you'll see some dashed lines behind that. That's to the rear. That's the building that Mr. Ogrodnik mentioned before has already been partially removed to satisfy the setback requirement. As the board may recall, that infringed on the setback to the rear. We've removed that, which also helped reduce some impervious. And there was a tennis court, which is in the lower left-hand corner of what's being shown. That tennis court has since been removed. So the impervious has been already reduced there. There is a stormwater management basin, which is in the upper right portion of the property that was proposed. That has also been constructed. And the septic system, or septic field, has been constructed as well. I will note, as far as stormwater management, although we're proposing the parking lot to be gravel, we have not changed that in the design calculations. It's still being considered a paved surface for the purpose of stormwater management. So should sometime in the future that parking lot be paved, stormwater management measures will already have been in place. Let's see. If we can scroll down to the entrance from South Branch Road.
You want to go up to the top?
This is good. This is good.
Okay.
Okay. As the board may recall, in the settlement stipulation, there is a requirement for a secondary access to the property. That was originally, and I have another exhibit I can pull up if needed to refresh the board's memory. That entrance essentially came off, if you were to extend the driveway to that's shown coming down the top of the page, if you were to extend that driveway straight down towards South Branch Road, that's where the emergency access was. It was a steep grade. It required significant grading, and it worked, but the county wasn't, Somerset County, because this is a county road, they weren't in favor of having a secondary access. However, they acknowledged the safety benefits as Mr. Winiger had requested. And back when we were resolving things with the emergency access, we did have a site meeting with Mr. Winiger, the county, and the engineer at the time, Bill White, and we discussed this. We ended up leaving the location of the drive where it was. However, the county had suggested that we move the entrance over to where the emergency entrance over to where we have it currently shown on the plan, which essentially now it's shorter and it follows parallel with the contours a little bit more. So it's actually a flatter grade. That would still serve as an emergency access. It would be chained off at both the entrance off of South Branch Road and also up at the drive. So that would be chained. And I know Mr. Winiger in his one review memo of August 26th had asked that it be chained and that there be no parking sign there. and do not block emergency access road, we would certainly do that. And
Hey, Tom, it's John Stamler
yeah,
with a question. So the county got involved because they didn't like the additional driveway onto the road, but, okay, so it was still kept. Well, why did they get involved with what happens on the property of that particular emergency access road? Why would they get involved with that particular aspect of the?
you mean as far as the alignment coming off of South Branch Road?
Right, you said they had an issue with the second entrance on South Branch Road, you know, the one, but it's still there, but you just changed the angle.
Right. They had concerns. Their initial review letter was they wanted us to remove the secondary access because they didn't want a second driveway for the lot coming in
Right.
off the county road.
Right.
So we had discussed it with them, and we explained that it was part of the stipulation, and it was part of what Chris had originally asked for, and we complied. We did have a meeting out there to try to see if there was a better way to achieve that. And actually, the engineer from the county had recommended bringing it over to this location so that it did not have as steep of a drive, and the approach to the road was the county road was not as much of a 90-degree. They were concerned with the fire trucks being able to access up there and so forth. And this was preferred. Now, obviously, we have to get approval from the county for this relocated drive. Back in, I believe, and Chris, you can correct me if I'm wrong, I think back in maybe February, Ralph Finelli and I stopped into the municipal building. We met with Chris and we discussed the layout and so forth. And we proposed this location. And at the time, Chris was amenable to moving the location down here. Again, this is one of the reasons why the impervious cover is decreased from what was originally proposed.
Yeah. So the fire marshal, has he been engaged on this thing, on this plan?
Chris can speak for himself, but Chris, if you could, I mean, I believe this is what we had discussed back in February.
Okay, before Chris comes on, Tom, I have a question for you.
Yeah.
Maybe the new entrance onto South Branch Road makes sense, but my concern is that emergency road is only about 40 feet before it connects to the public access. And that gets you two, I believe, two of your bigger fire trucks on there. If you have a jam up by people assuming the barn's on fire and you have a big crowd and people are going to be trying to leave, they could be blocking that lower part trying to get onto South Branch Road. Is there any reason why you could not make that emergency access more perpendicular to South Branch and join it up near the fourth tree onto your public driveway? Why can't you make it longer, almost as long? I think the initial one that was approved was about 100 feet. This would get it close to 100 feet. So it would be longer so that the trucks and the fire, the police cars and everything that shows up in an emergency like this, that they would have a longer access road to themselves before they may or may not hit public traffic trying to get off the site.
Well, Chicky, I understand what you're saying too, and I want to hear from Chris, because I don't know how, when I see that additional emergency lane, what are you saving here? Because if you're going to be blocked by cars, you're going to be blocked by cars right at the original entrance. So I would like to hear from Chris.
And if I can add, just from a dimension standpoint, from south, coming along the main driveway from South Branch Road up to the emergency access is 100 feet.
I'm talking about the access road itself. That's only at least, what, yeah, that.
You mean as far as its width?
No, it's length.
Oh, its length? That's about 100 feet also.
Yeah.
That's 100, okay, well, then the original one was about 300 feet, correct?
Ms. Haynes, Mr. Decker referred earlier to the fact that he has another exhibit. I believe I know what he's referring to. And perhaps it would be useful for everyone, particularly people who are not familiar with what transpired before, to see the original diagram so that they can make a reasonable comparison.
Yep. If we can pull up it's the plan called titled Render, and it's got a 12/19/16 date on it. It's right above the one that you just opened.
Yep.
And Tom, yeah, just from looking at that diagram, I don't know what we're buying by, you know, having a dual access when you're only talking about 100 feet, when I think the original proposal for the 300-foot emergency lane was to eliminate or divert getting caught up with the exiting cars and all. So, you know, to me, it looks like you just eliminate what is being proposed now, because 100 feet is nothing.
Okay, if we can scroll down on this exhibit, just to touch on that, and Chris can correct me if I'm wrong. One of the reasons why, for the secondary access, I believe my recollection is Chris's concern was if there was a blockage at South Branch Road. So say at the main entrance, the emergency service vehicles, for whatever reason, could not access at that point, they would have a secondary access on South Branch Road.
Yeah, okay. And I'll wait to hear from Chris too, because, you know, by all means, he's the expert with being a fire marshal. So I would like to hear from him. And if he can get his trucks up there and all, and he's experienced everything, I would like to hear from him.
No, I understood. So what we have here, this is actually the rendering that was presented at the original site plan back in, I think it was 2000, it may have been 2016.
Present it, I'm sorry, Tom, present it, or this is the approved plan?
This was,
approved.
This is the approved plan.
Okay, thank you for clarifying.
Yep, this is what was approved. So you can see, this is where the emergency access is. And one of the things, going back to the question of what are we buying, you can see there's grading shown there, and the grading on that is significantly steeper than the proposed access. So from a vehicle access standpoint, it's steeper. By moving it, we flatten it out a little bit or significantly, because now we're running more parallel with the contours. I do have in the package, I also have exhibits of the profile of the original proposed and approved access lane and a profile of the proposed access lane to show the difference in the grade. The other benefit by moving it over is that there's better sight distance along South Branch Road. While we achieve minimum sight distance in the original layout, the proposed layout provides even more sight distance, particularly going towards the west.
Tom, I don't recall your testimony going back to the original 2016, 2017 plan that you had any objections to the location. I think it was your plan to put it there. And I know that Chris has been concerned recently, and we'll, we'll hear it from Chris, that somebody said it wasn't feasible. Well, from an engineering, we're not talking cost, but from an engineering perspective, I'm assuming that what you put on the plan in 2017 was feasible from an engineering standpoint. Is that correct? It might be more costly and it was a steeper grade, but was it?
It is. It is. I believe when we were having the discussion about the entrance, we did propose, because this, remember, I had mentioned that we had a meeting at the site with Chris and Bill White and the county, And at the time, we had this as a sketch where we actually had this as a sketch, and we're talking about other options. And this is the one that, that we went with.
Well, Tom, what other options are we talking about that you're saying?
Well, I mean, basically, this option was coming straight down. I believe this may have been what was discussed during the use variance application. Unfortunately, I wasn't there for that meeting. Bob Heibel was filling in for me at that.
Okay.
And I believe Bob may have indicated during the meeting that it could come down in this fashion. Again, we believe that the better approach, the flatter approach, is to move it over, less impact to the trees, less impact to the steep slopes, and in a flatter, a better way to do it. And at least at the time, it was more favorable to the county for their access off of South Branch Road.
Wait a minute, you're saying it was more favorable to the county?
It's more what we have currently proposed. The access being closer to the main entrance was more was preferred by the county over what you see in front of you here.
So you're saying the county is changing its position?
No. No, the county, originally, the county didn't want any emergency access. They didn't want any other driveway, but they.
Wait, is that true?
Yes.
Okay.
Well, but then how could you put it on your 2017 site plan that we approved in 2017?
Because what had happened was the county issued a letter saying that they didn't want the driveway there. However, there was the stipulation, the settlement stipulation, which required an emergency access. So the county issued a follow-up letter saying, okay, we understand that there's now there's a settlement agreement that requires this access. So it has to go in, but it has to meet the county requirements and so forth for approach to South Branch Road, which required additional grading and so forth. So they changed they didn't really change their mind, but they accommodated the settlement agreement with the town.
Hey, Tom, it's John Stamler.
Yeah.
I'm gonna just cut to the chase here. With both accesses, what's the cost difference between, and I'm not saying cost is coming or being suggested as a cost saver or anything. What's the difference in cost with the two?
I don't have that number off the top of my head. I'm going to say that it's going to be, what we're proposing is probably half the cost of what was proposed prior.
Okay, thank you.
This is Tom Neff. I have a quick question. If you have this information or not, can you quantify what the difference is between the two slopes and grades? I see the original profile of it looks like it was 11.2% from your plan, which I would agree is rather steep. And then you submitted a second profile, which does look much more gradual, but I don't see a grade or slope percentage on there. Do you have that number by any chance?
Yes, actually, if we can open up another exhibit, and it would be amended site. It's titled amended site 9/15/2011, and it says emergency access. It's the third one from the bottom of the list on the website.
Can you put the site plan back up a minute?
Hey, Frank, we have Chris. He's gonna speak too, right?
Right, I'm waiting for him. Like I said, I want to hear what Tom says. I have a couple of questions myself for Tom, then we'll go to Chris because he's.
All right, go ahead, Frank.
Hey, guys, real quick, for the record, Tom, this is something new that wasn't included with the original plan set?
Correct. This was not included with the resubmission. I apologize for that. This is something that we thought might be helpful in demonstrating the slope of the drive, and I see that we did not label that slope, but I can figure that out.
Is this in the current plan? This isn't,
This is the current emergency access we have shown.
right, the original plan approved in 2017. Right?
No, this is what we're proposing now. If you want to see the one from 2007,
That was going to be one of my questions because you got a sheet 6A and a sheet 11 that showed the fire trucks going up the grade and other information about that. And it wasn't in the site plan that we received.
now this, and I apologize for that. This is actually let's see, this is, I believe, the same sheet 11 from the 2017 set, but revised to show the new emergency access location.
Okay, so this will be put back and this will become part of the current proposed plan then.
Correct. If you'd like to see the old
Tina,
location,
I'm sorry, Tom, Tina, you might want to mark this since it wasn't included with the original plan set.
Mr. Chairman, I understand Mr. Gorman's concern. I was concerned about it, then I thought there was a resolution. Now I'm not so sure. Is the drawing that is currently on the screen, is this part of what's posted on?
No, it's not on Civic Clerk.
It's not on Civic.
Excuse me, Chairman, this is Fred Kinsler.
Yeah.
This was given to me by Eva,
Right.
our planning, and I believe it is on Civic Clerk.
it is.
Because I just picked up a full set on Friday and this was not in that set.
Correct.
I sent an email.
Correct.
I think that there were things added recently, but the simple answer is if we can confirm this is on Civic Clerk, my recommendation is as it was before for other things that are on Civic Clerk. If it is not, then I take Mr. Gorman's point that somehow this needs to be identified as a new exhibit.
I am able to view this from Civic Clerk. I see the link on there for it.
Okay, is there also a sheet 6A?
So, excuse me, Mr. Chairman, this is Fred Kinsler. I have on my screen here Civic Clerk. And this is, I'm sorry, Tom, can you rename that? Amended site plan, I'm sorry, what was the number? 2011 emergency access?
The one that you have up now,
Yes.
that was the 2011 emergency access.
Yes, and Mr. Chairman, it is on Civic Clerk as CCC BA 1610 amended site 9/15/2011 emergency access. It is there for the public to see.
Okay.
Okay, that's good.
Okay.
Thank you.
So this is what's proposed, I believe, because the file names are different than what I have. I believe the original approved fire lane is shown on the one that's 102417 Emergency Access Road.
I can assume Chris saw this.
Yep, that's it. That's it there. Okay, so this is what was originally proposed. And you can see there's an existing grade line. That's the amount of.
But you're saying proposed or approved?
This was what was originally approved.
Okay.
Okay. And you can see the dashed line is the existing grade, the solid line is proposed grade, and each one of those horizontal lines represents 5 feet. So you can see that there's a significant amount of excavation and cut in there, and you can see how steep the drive is at that 11.2%. Now, if you were to flip to the other plan that we just had up, that one, you'll see that in the profile we have a much less cut with the embankment, so that's less disturbance, and the grade is flatter than what was originally proposed. So
Tom,
that's
this is,
Originally approved.
but,
I'm
yeah,
sorry, originally approved.
Tom, but the proposed is much shorter and is down towards the bottom, towards South Branch Road, which is not not the steepest part. The fire trucks are still gonna have to go up what you're proposing, mostly on the public driveway, which gets to be quite steep itself. Is there any reason why your proposed one can't be made longer and parallel closely to the existing public driveway? You know, cost should not be the factor here. You
No,
want to get your emergency vehicles up there as quickly as possible.
Hey,
No,
hey, Chick, yeah, hey, guy, hey, Chicky, I understand your question, and I think I've understood it a few times already. Can we wait, can we hear from Chris, and then we can ask some more questions about what you're talking about? Because we're concerned about the emergency vehicles making up there with a full parking lot of people coming down, right, Chicky?
That's part of it, yes.
Right, so I would like to hear from the fire marshal.
Well, let's complete the, with this witness first. Certainly, it's important to hear from the fire marshal separately.
I believe, there were a couple things in your engineer's report. I think I've addressed most of them. There were a couple questions as far as the DEP permitting and letter of interpretation. The LOI was issued for the site on January 24th, 2017. That has a 5-year life to it, so that doesn't expire until January 24th, 2022. We also have permits for the entrances, the approved entrances off of South Branch Road, because they do cross some wetland areas there. Those permits were issued on August 14th, 2017, and they remain valid until August 14th, 2022. I will say, by moving the access drive to the east, as we have proposed, we will need to get an amended permit from DEP for that location. Which we will do subject to, if this meets with the board's approval, we would certainly accept that as a condition of approval, that we obtain that permit. I believe we had addressed all the other items, unless.
I just have a couple comments, questions. Regarding the potential revision to the access drive, we did get turning templates for what looked like a right turn in for a fire truck on the main driveway. We would just also like to see the full movement as far as egress out of the site as well. And would they also be making, I'm assuming, a left into that access drive?
That would, one of the things, and that's an interesting question, because one of the things that we did look at with that access drive was that it did provide a better approach from the west. And I believe, I'm not sure, Chris can correct me if I'm wrong, but the Shannick Volunteer Fire Company may be one of the responders here, and they would be coming from that direction. So rather than having a straight 90-degree up from South Branch Road, with these two accesses the way they are, you really have kind of more of a sweeping access into the site from both locations. But we can certainly provide those turning radii to you.
Thank you. I do have some concerns over the gravel parking lot. I think that some of the other board members discussed as well. As far as long-term maintenance of it, is it going to be striped, or is it just going to be wheel stops? If you are just proposing the wheel stops, it looked like they were, at least on the plan, only on the outer perimeter, not on the interior row of parking stalls as well. So I'm just, curious long-term how they're going to maintain a gravel parking lot and maintain an orderly parking stall count and not end up with cars kind of all over the place.
Well, I think a good example of how this can function is the Neshannock Reformed Church at the three-way stop has a gravel parking lot that they utilize. They do have, they do stripe the gravel. That does seem to function well. I live around the corner. It doesn't usually seem to have any disorganization to it. They are able to clear it in the wintertime for folks to access. They do have some hardscape for the ADA parking spaces, and I know some paving blocks and so forth. So I would offer that as an example of how this can work for a house of worship.
So I would just say, if the board were to agree to that, and I will note it is a waiver also, section 188-68G does require paving, at least on the driveways and aisles. So a waiver would be required for that, I believe. My recommendation is always to pave the parking lots. I just think it's a better long-term solution. I understand maybe a unique circumstance out here. So if the board were to grant it, I would just recommend that the wheel stops be provided at all of the stall locations, not just the outer perimeter, because that'll help define the spaces a little more permanently.
I believe we can create it out.
Thank you. One other question I had was regarding landscaping. I didn't hear that mentioned at all in any of the changes, but in just looking at the two renderings, the prior approval and the current proposal, it looks like there's a pretty significant amount of reduced landscaping. A lot of the trees that are no longer proposed around the driveway entrance and the whole parking lot. Is that the case? Or are you looking to change landscaping, or is it going to stay as originally approved?
The landscaping will stay as originally approved.
Okay. That's all I have at this time. Thank you.
Questions from any other members?
Mr. Decker, it's Pat Gorman. Just to confirm that the proposed driveway and the emergency driveway will be paved asphalt?
Correct. There'll be paved asphalt, and a portion of the main driveway will also be striped as a fire lane per Chris's request.
And then you'll have no parking for signs and the parking lot instead of striping, correct?
Correct.
Thank you.
I have a couple of questions myself. Okay, so we'll wait for until Chris tells us what the purpose of the emergency access road is, but assuming that it's to get a lot of fire engines to bypass illegally parked cars, how many parked cars would be in the first 100 feet on the proposal if there were illegally parked cars?
You mean between the
road and where the emergency access comes in? How many cars would possibly be there?
over 100 feet, maybe 5?
Okay, now, in the original approved version, how many cars would be in that length?
There would be obviously.
I'm sorry?
Obviously, there would be more.
Okay.
I don't know exactly how many.
So it'd be 2 or 3 times many cars at the
Correct. You could be looking at 10 to 15 cars.
Okay.
Hey,
So
hey, Frank, I'm sorry to interrupt. It's John Stamler. But you got to remember, in an emergency condition, these cars aren't going to be parked. They're going to be exiting.
well, the other side of my coin, if another purpose is to get the fire trucks past exiting cars, it's still going to be the same number of cars whether they're parked or exiting, right? I mean, the further up this comes in, the more cars exiting or parked the fire trucks can pass. That's my point.
Yes, that's a good point right there. That's correct.
Okay, and you confirm that sheet 6A and 11 on the original approved plan are now in the current one as of today.
As of today, by way of.
Question about the gravel lot. Fred, could you just bring that the ADA area back up on the diagram?
You want the first aerial, the new current aerial?
Right.
Yeah.
I
Okay.
just want to focus in on the ADA spot.
Yep.
Okay, maybe you can zoom in on.
Yep.
Okay, so my question is going to be if a vehicle, let's say a van is parked in one of those and somebody's in a wheelchair, do they have to be pulled across the gravel or they have to negotiate the gravel area or can they get into the building on a paved surface? So let's say I'm in the topmost spot.
If you're in the topmost spot,
And I'm on a wheelchair. How do I get into the church and onto the other properties?
the space just below that is also paved and striped with,
Okay.
with no wheel stop, and that accesses the sidewalk in front of the church.
Okay, so they can reach the sidewalk.
Correct. Same,
So they don't have to go across the gravel with a wheelchair.
correct. Same thing with the other two spaces that are there.
Okay. Second question I have about gravel. So the problem with gravel is you can't go down to the surface or else you move all the gravel in the wintertime when you're pushing snow, right? So you have to leave an inch or two of snow in the place. And what happens when the sun comes out, that tends to ice up, it melts and then it ices up. Is that a dangerous, is that a hazard problem for people that need to negotiate the parking lot?
You mean from a pedestrian standpoint?
Yeah.
I suppose there could be issues if it's not cleared properly and salted and so forth to clear it. You would have that situation if a paved driveway or parking lot wasn't plowed properly either.
Right.
I understand the question that, a paved parking lot obviously is easier to clear snow on.
Right. So you think they could still solve the problem by just dropping more salt and
Probably. I mean, again, I go back to the location at the North Branch Reformed Church. It seems to work fine for them. That's been that way for. I've been living in that area for 30 years. It hasn't really changed.
And I got to say, every time I pass that church, I'm remarkable that the stripings don't move more than they do. They seem to stay in place somehow.
Yeah, they do seem to stay in place. So. It can work.
Okay, that's my questions.
And it's John Stamler to add to Frank's. Is there any type of drop-off point, for instance, if it is snowy and all, can folks drop off close to the building?
Well,
Or-
there is a pull-off area. It was just indicated before, off to the right there, which has a patio next to it, which then has a sidewalk which would connect to the barn. So someone could be dropped off there. The church could, for a drop off, they could designate those two lower non-ADA spaces that are paved as being.
I would suggest, I would definitely recommend that because, in the winter time, if it is a banquet going on or a large celebration or whatever, nobody's going to know about that back side road there.
Yeah, no, that I think that's something that could be managed during special events, and use those two spaces as a place where someone could pull in, drop someone off, and then go park elsewhere in the lot.
Yeah, I would recommend a drop-off point for bad weather.
So any other questions from members of the board? If not, we'll ask for a motion to open public.
Mr.
I
Chairman.
got one question. Tom, this was approved. Everybody was okay with paving it back then?
Yes, yeah. Originally, it was approved as being a paved parking lot.
Okay.
Mr. Chairman, if the rest of the board members don't have further questions, if I may, I'll ask a couple of Mr. Decker.
Go ahead.
Hey, Mark, I'm going to just interject with one more question for Mr. Decker, please. Hey, Tom, it's Pat Gorman.
Hey, Pat.
The parking lot still has the island trees, correct?
I'm sorry, the parking lot still has,
The trees in the parking lot, they are on island?
Correct. Yes.
So they'll still be out on island elevated and they'll be protected somewhat. So if this was a gravel driveway and now you're introducing salt instead to a gravel driveway, that there would be less salt absorption, which would kill the tree, which wouldn't kill the tree, right?
Right. I mean, if it was paved, it would be salted as well.
But you'll have runoff from that instead of being absorbed more into the
Correct.
ground.
You're right. In this case, the salt would be more, it would stay in place, if you will, and not necessarily run off into the landscape areas.
Yeah, so it's concerned about the tree survival at that point.
You're concerned with the tree survival of the salt being absorbed into the gravel
Correct.
as opposed to being,
Washed away on asphalt.
I thought, okay. I thought the concern was more of it washing off of the asphalt into the islands and affecting the trees.
Depends how it's constructed.
I'm sorry?
It depends how it's constructed.
Oh,
So so basically what you're saying is if the islands were raised a bit above the parking area, so that any of the runoff from the parking lot would go around the islands and not affect the trees, that would be acceptable? Because we can certainly do that.
I would defer that to our board engineer, but it's something, I just don't want to see these trees planted, and then if for three seasons or heavy snow or heavy salting during the season, that they die as a result.
Okay, well, we would probably have that same concern. There's no curbing on the parking lot, and any of the trees that are planted around the perimeter would be subject to salt runoff as well. So we can certainly work with the engineer on, potential solutions to that.
Thank you.
Mr. Decker, Mark Anderson, Board Attorney. A couple of questions about going back to the question of this emergency access. First of all, just so I'm absolutely clear on this, the difference in the plan affects a driveway which is intended solely for emergency access. Is that correct?
That's correct.
All right. So, I mean, by the nature of that, this would not be in daily use or even really infrequent use. Am I correct?
We hope it's never used.
Well, that was exactly my point. It would be used only for, I guess, when it needs to be maintained. And if there were a fire, which of course we all hope there isn't.
Correct.
Ms. Haynes asked a question earlier about the originally approved plan. That is the driveway that you described, I think correctly, is coming essentially straight down to the public street from the upper section. And unless I missed it, I'm not sure there was a clear answer to that. As I understood her question, is there any question that what was proposed before and approved by the board could be constructed?
No, it could be constructed. My opinion is that the currently proposed design is a better design.
All right. Yes, well, I think that your testimony was eminently clear on which you thought was better. I just wanted clarity on what I thought may not have been answered before. And along those lines, and of course, we're going to hear from the Chief Fire Marshal, I believe, next. But I'm looking at his memo of September 1st, 2020. I presume you have a copy of that.
Yes.
There is a sentence in particular, and let me read it to you. This is, of course, authored by the Chief Fire Marshal and speaks in his voice. I was under the impression that the original design was no longer feasible and that this new proposal would be the only option that addresses the grade issues while providing secondary access. And I want to confirm as to the first part of that. Mr. Weniger indicates an impression that the original design was no longer feasible. By original design, I assume, again, he's referring to what I spoke about a short while ago, that which was originally proposed and was approved by the board. Is Mr. Weniger's impression correct that the original design, quote, was no longer feasible, unquote?
No, I don't. I don't know that we ever said that it wasn't feasible, because we did have it designed and we did demonstrate that it could be accessed. We had the reason why we went back to Mr. Winiger to talk about it was, again, to try to accomplish what he was looking for as far as a secondary access, and at the same time save the church some expense, because as you indicated before, we hope that we never have to use this, and it's for emergency purposes. So that was the intent. And then again, based off of we thought that the county would also look favorably on it, because that was one of the suggestions that they had at our field meeting back in 2016 or 17.
All right, well, of course, the chief fire marshal can speak for himself, but since this section of his memo appears to suggest something that came from someone else, I wanted to confirm with you whether the impression was
No, and if that was not communicated well by myself or Ralph Finelli when we were there meeting with Chris, then I apologize if there was confusion. But no, our intent was not that it wasn't feasible, just that it created a steep driveway, more disturbance, more cost. We thought that we could accommodate what the fire marshal was looking for with locating it where we currently have it proposed, with a better design as far as it being flatter.
And what I hope to be my last question about this is, your testimony indicated, as I understood it, that the county, let's say, wasn't thrilled by any secondary access. Again, as I understood your testimony, the county was willing to accept secondary access. But if you could answer the question, if you know, is there any reason to believe that the county would not approve the original proposed and originally approved design if that were the board's decision?
Well, the county has approved that original location, and they did it because it was part of the settlement of stipulation. So it was approved. However, I was trying to see if I could find that letter, the original letter. It was in the fall of 2017, where they basically originally said they didn't want it at all.
All right, well, I think you've very completely answered my question.
Okay.
Frankly, I didn't realize the county had approved it, so it clearly answers the question of whether you would expect that they would.
Yeah.
Thank you.
Yeah, just so everyone knows, all the agency approvals were obtained, resolution compliance was obtained, and the original site plans had been signed off by the township, so that everything had been in order.
All right. Thank you, Mr. Chairman. Those are the only questions I have for Mr. Deckman.
Okay, so we're ready to open it for public. Do I have a motion for public?
So moved.
Second?
Again, Janine.
Second.
Janine, second. Those in favor?
Aye.
Any
Aye.
opposed? Not hearing none.
Aye.
Okay, at this point, we'll open up the lines for anybody in the public that has questions for this witness. So Fred.
Okay, anybody from the public that has a question for this witness on this application, please raise your hand.
You're not public.
Seeing none, Chairman, you can proceed.
Okay. Mr. Ogrodnik, and your next witness.
Thank you, Mr. Chairman. I don't know, Mark, if you want to have Chris speak to this now, or we can move on to our professional planner, Art Bernard.
Mr. Ogrodnik, of course, it's really up to the applicant to make the choice. Although I will say my sense is that the board was hoping to hear from the chief fire marshal next to tie the testimony together. But again, that was my impression. That's your impression, your application.
Okay, well, I know that Chris is here. I just wanted to perhaps ask him a few questions, with respect to the access and, is it sufficient? I know we spoke a lot about the location, but we did, the testimony from Mr. Decker was that we were widening the primary access to allow for a two-way traffic. So I guess my question is for Mr. Wenninger. Do you think that the proposed plans, taking into account the grading issues and the county's concerns, is an adequate secondary access? And I guess my follow-up question is, what is the concern here? I mean, obviously it's a structure fire, but where would be the choke point? I mean, I'm trying to think of a scenario where there's a traffic accident blocking 2 lanes of traffic in the primary ingress and egress. So that's generally my question. What's the concern from a fire response perspective?
Excuse me, Frank, do you have to have him swear in as a witness, or we're fine with just this?
My recommendation to the board is always that those people who are employed by the township are not required to be sworn. The chief fire marshal is slightly different in the sense that he works for a different department. I guess my suggestion is that it would be appropriate if he were sworn.
Okay, Tina?
Yes. Mr. Wenninger, can you raise your right hand? Is your right hand raised?
Yes, ma'am.
Okay, thank you. Do you solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, proceed.
Okay, so to answer the questions posed, just to clarify, the main reason in this particular site that a secondary emergency access was requested was for 2 reasons. The first reason is that we never like to see a single access to any property. The reason being is that if something happens to that single access, whether it's a power line that comes down, a tree that comes down, a car accident, flooding, whatever, pick your poison, that affects that, we essentially are cut off from either going into the site or coming out of the site. Excuse me. The second reason in this particular site that we had requested a secondary access was there is no water on site with the exception of that tank. So even with the tank up there, there's going to be the need for us to have to bring our own water supply. And there are 2 ways that we can accomplish that on this site. The first way is to bring tanker trucks full of water up and down, up to the site, dump their water or have their water used at the fire, and then egress back down to South Branch Road, travel some distance to a fire hydrant, refill, and then repeat that process. The second way that we can get water to that site would be to do what's called a shuttle operation, which would be bringing a water tank, a portable water tank that we carry with us, dropping it at whatever location is determined, and that same process occurs. The water tanker comes, drops their water into that folding tank or that portable tank, continues on its way. The next tanker comes in, dumps their water into that tank, etc. Simultaneously, water is being drawn out of that tank by a pumper truck and being pumped up that driveway to the fire scene. By having the secondary access there, what it allows is that shuttling of water to continue without having to have the tanker trucks pass each other, one coming in, one coming out, as one example. It also allows a secondary access, so if we have fire hoses or other emergency vehicles that are parked along that roadway leading up to the scene, it just allows us more room to allow for safe access. The grade is obviously a concern. These are big, heavy trucks, and they don't operate on grade as well as obviously on flat streets. We don't want to have the grade so severe leaving from the street where we have an issue where the back end of the truck strikes the roadway or bottoms out. And so that has to be addressed in the engineering. And honestly, looking at the paperwork I received today, it's kind of hard to tell on this new proposal whether or not that would be an issue. It's very difficult for me to read some of the diagram there. So those are the reasons primarily that we like to see a secondary access. There was mention of cars leaving and us approaching simultaneously, and certainly that is a concern that would also be addressed by this. But again, the primary reason is that in the event that something happens and the main roadway is blocked off, and also giving us kind of a circular plan where we can come in and come out without having any kind of a bottleneck or getting in each other's way.
I have no other questions.
Hey,
Thank
Chris,
you. I appreciate it.
Chris, it's John Stamler with a question. So, my $1 million question was going to be, and you just answered it because you can't verify based on the diagrams that you have in front of you or the ones that you saw. I was going to ask you with the approved fire access plan and the new proposed modification, which would you prefer? Would they both work? But you're telling me from your last comment that you can't make heads or tails of what you have in front of you or what was provided?
So they both will work. The plan that we just got, again, I'm not saying it won't work. I'm just saying that in the 8.5 and 11 by 11 paper that I got, if I'm looking at it, the right-hand side, there's a picture of the fire truck shown on the grade, and it's just very busy. It's very difficult for me to tell with that angle of approach and everything, what would work and what wouldn't. So again, I'm not saying it won't work. It's just hard for me to tell by this diagram.
Chris, this is Chicky. When did you get that diagram?
Like 2:30 this afternoon.
Oh, boy.
Chris, would you have a problem, say we move forward with this application, and one of the conditions would be based on the fire marshal's recommendation, would you have a problem deciding on which fire emergency access would be better, or what you would prefer?
Well, honestly, I mean, like I said, they will both do what we're proposing to do. The originally approved plan, we know, based because it was approved at that angle of approach, to my recollection, would work, and it does give us a little bit of a more direct route out to South Branch Road. But again, either one of these addresses my concern. So there is, again, 6 of one, half dozen of the other at this point. I just would need to verify that this new proposal, the grade issue wouldn't be a problem with us.
Okay.
And we would be happy to make that a condition, both with the township engineer as well as Mr. Weniger.
Excuse me, this is Fred Kinsler from the township. Would it help if I pulled that document up for Tom Decker? Would it be helpful if I pulled that up for Mr. Weniger and blew it up, and that one that has the fire trucks on it?
Bring it back up, please, and
Well, if I could just interject, I'm actually on my phone, so I don't have the ability to see what you're looking at. I'm looking at the paperwork that was sent to me today, marked page 11. And on again, on the right side, about halfway up, there's a fire truck, but it's just very difficult for me to see because it's very busy.
Right, bring it up.
There's lines.
Hey, Frank, hey, listen, if he can't see it, he's the expert and we want him to see it. So if he can't see it, well, I don't want to just delay this meeting, but Chicky, let me ask you, Chicky, if we motion with this and make it a condition based on the fire marshal's recommendation, would that be fine with you?
Well, you know what, I'm not the only person on this board.
No, I
Well,
understand. I'm just
John,
asking
hey, wait a
you.
minute, wait a minute. I'm not going to commit one way or the other. I guess I'm concerned. The first one has been approved by the county. Chris has said it'll work. My concern is it's longer and there's less distance where the public leaving is going to, clog it up. I don't know if Chris, if you feel the same way about that. The longer the better, because it will not mix your public traffic trying to exit. And as you said, you want to, your trucks have to be able to circle around, take the water up and then get back down. And if you've got 50 some cars, probably many of which are trying to get out of there, I would think the longer the emergency access road, the better for fighting the fire. Is that reasonable or not, Chris?
If we still have people that are attempting to leave the site when we are arriving and operating, then yes, that certainly would be helpful. I just don't know how many cars we would have leaving while we're operating. So that, again, the first driveway was acceptable. It was fine. It will do the job, assuming that, again, I don't have all the details in front of me, but it was originally approved, which is why, again, when we saw the second one, I wasn't honestly taking into account so much people exiting, although that is a valid point, as I was more of looking to get us, being able to get in and out of there quickly and efficiently.
Yep. Thanks, Chris.
Mr. Decker, this is Tom Neff again. Maybe, I don't know if you had a chance to look at it, but kind of going back to what I was asking earlier, the previously proposed and approved emergency access profile showed a 6% grade coming off of the main road up to an 11% grade. So if that was acceptable to the fire department, would the new access drive, we don't have the numbers on that profile. Do you know, are they equal to or less than the previous one? You're on mute still. There you go.
Yeah, they are less. They are less than that, the 11%. And I can certainly calculate that and get it.
So if the fire trucks were able to get in the prior one, they should have no problem getting in the revised layout.
Correct.
Okay.
So if I could ask Tom, do you know what the angle of approach was on that original proposal as opposed to this one? Do you happen to know that?
The angle of approach, you mean from a grade standpoint, or from the turning off of South
So
Branch?
I'm looking at the fire truck leaves South Branch Road onto the driveway. I can't have these trucks bottoming out as they're heading up that grade.
Oh, no, on the original approved one?
Yes.
No, we had, that was one of the exercises that we went through, because I know you had given us the specs on the truck, and that's one of the reasons why we had that exhibit shown with the fire truck, showing that it does not bottom out. To be honest, I mean, it just clears, but it doesn't bottom out. And that situation is improved with the currently proposed location.
Thank you.
Mr. Chairman,
Yes.
I have a comment, and this is unrelated to any kind of engineering.
Well, you really can't jump in here, Pastor Nash.
I can't?
You cannot, no. We're already violating one witness at a time by letting these two guys speak, even though it's very productive. But you'll have a turn to speak later.
It's related to this emergency access.
I'd rather you didn't, because we're going to totally confuse the court stenographer. So
It has to do with children.
okay, you can tell us later. Mr. Grodnick, you can bring him up as your own witness later.
Unless there's any further questions for Mr. Wenninger, I could bring in Pastor Nash just for a brief comment, and then we're gonna
Just a comment.
I have a couple of questions myself, and I'm not.
Okay, so let's, Pastor Nash, we're gonna wait for your turn. We're gonna speak with the fire marshal right now.
Okay.
Okay, so my question, I thought that the primary reason, the longer the better, was to, so the fire trucks would bypass more congestion with a longer driveway. And you're saying that's not that big of an issue for you? Chris?
It wasn't the primary reason that we requested this, but it certainly is a benefit.
Okay, but if it's shorter, it's not a showstopper, are you saying?
The way that it's laid out now, it's not a showstopper, no.
Okay.
But Frank, it's John Stamler. It's hypothetical, because if there's a banquet going on up there, Chris doesn't know how many people are exiting. So, watch where you're going.
Yeah.
So just my understanding is that this is a place of worship. I'm not aware, or at least I don't recall being aware that this had multiple uses for a banquet facility. So if that's the case, then that certainly becomes a bigger concern of ours.
Chris, yes, it absolutely is. They will have, that was made clear the first hearing, where they will have wedding receptions and other types of, and Pastor Nash can speak to this, but the testimony we heard before is that they plan on having major events, not just worship.
Yeah, I agree, Chicky. And I think, wasn't there also going to be a camp up there too?
Yep, there were going to be some summer date, not overnight though. I believe Pastor Nash said that, but there would be summer Bible school and youth activities and things of that sort.
Yep, that's correct.
We need to be a little careful about referring back to the prior case. The testimony in this case has to stand on its own, but the issues that Ms. Haynes raises, I think, are in the prior approval. They are a matter of record as to what was approved for the site.
Yeah, thanks, Mark.
And I have a question for Mr. Wenninger, if he's still testifying. This is Jim Wallmacher. I'm one of the board members. I don't think we've had the pleasure of speaking before. You can see the new site plan where with where the proposed driveway is going to be. It kind of forms a triangle with the existing driveway and South Branch Road. Do you have access to that drawing? I know you're on the phone.
Yes, I do. I have that. I have it in front of me.
You mentioned that one of the purposes of having the access road is to do this sort of shuttling of delivering water to the site. And so that the trucks don't have to kind of back out, so that there's a way for them to sort of loop around. Would that actually be facilitated by the new plan, given that it's a shorter distance for them to have to loop and potentially drive less on the public driveway?
So the way I'm looking at this is that the truck would go up the driveway to where the fire would be, one of these buildings up here, would use that parking lot to turn around and change direction, and then would come back down, and because of the width of the driveway, would then make that right and then out to South Branch Road, and either then go left or right, depending on where the established area to get more water would be from. Does that answer your question?
Oh, I thought when you were talking about dropping off that sort of temporary tank, that would have been done on the access road, and that the trucks would just be kind of delivering it to that spot and then turning around and leaving again.
So if we were to drop a temporary tank there, most likely it would be dropped somewhere on that access driveway, closer to South Branch Road, or actually on South Branch Road. So we would leave at least one of those driveways accessible, so more trucks could actually go up to the scene.
Okay.
And then the refilling would occur. If you can imagine, you're coming down South Branch Road, you stop at the tank, you drop your water in the tank, you continue on your way until you get to the fill site.
Got it. Okay, understood.
As I testified, as I recall previously, having buildings of any kind of size in a rural area where there's no public water is much more equipment and manpower intensive. So, more having this room and these available driveways prove to be, kind of crucial to that.
Okay, thank you.
Yeah, this is Frank Carver, Chris. Okay, so I have one more question. Why does it matter? What's the difference between having 150 people at church and 150 people at a wedding reception in the same building?
There is no difference. I was assuming that the banquet would have more people than a church service would. That's in my experience what I've seen in many of our houses of worship.
I think we have a limit of 150 people in this building no matter what. But
So then 150 people is 150 people. You're absolutely correct.
okay. Any more questions? Okay, so let's open it for public questioning for this witness. Fred.
Sure. Anybody from the public have a question for this witness on this application, please raise your hand. Seeing none, Chairman, you can continue.
Okay, Mr. Ogrodnik, the next witness.
Can I just ask, do I need to stay on this call or am I free to?
I think you might, it'd probably be a good idea.
All right, we're done, Frank. He's fine.
Think so?
Yeah.
Questions never come up from
Sir.
first.
Oh, wait, no, I have one more question for the fire chief. I mean, one thing I wanted to know is, there's a pretty large pond on site. Could that be potentially used for a fill site?
So when we had the site visit that Mr. Decker spoke about before, we looked at that situation. The access to that pond to be able to get a heavy fire truck there to pump out of it is not feasible, and we don't know what the condition of that pond would be either in the dead of winter or in the drought conditions. So we're not considering that as a fill site.
Thank you.
So if we let Chris go, you're not going to be able to ask any questions that might arise from the next witnesses. But everybody's okay with that?
I'm good.
Okay. Thank you, Chris.
I can also, you're welcome. Patrick can also reach me, and if you need me to come back on, I'll be happy to do that.
Okay, that's a good idea. Good, thank you.
Okay. Thank you.
So I know my client, Pastor Nash, wanted to just briefly make a point, and then we're going to move to our planning testimony with Art Bernard.
Okay.
Do I need to be sworn in, or is it okay? Just to make a comment.
If he is giving testimony, definitely, yes, he needs to be sworn in.
Yes, Tina.
All right.
Pastor, do you solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. The concern that I had that no one has addressed about the original plan for the fire access road is the steep, very steep embankment on each side that would be created by grading. This would be a hazard probably a hazard to the very place where most of the children play on our site. And now you say, well, we could put up fences down each side of that. Children have a way of getting around fences, top or bottom, and also the road itself is asphalt. So you fall down a bank and you hit your head on asphalt. That's not attractive. And along with that, Chris just mentioned that fire tanks or these extra tanks that they bring in would be put on the access road possibly. You're never going to put a tank on a bank. It's not going to happen. So I would encourage the board to approve the proposed and new plan for the access road.
Thank you,
all I have
Pastor
to say.
Nash.
Thank you.
For my final witness, I would like to introduce Art Bernard as our professional planner. I know he's testified recently before this board, so I'd ask that his credentials be accepted and he be sworn in.
Mr. Bernard, you got to unmute yourself. This is Fred Kinsler.
We open for business now. There we go.
There you are. Mr. Bernard, can you raise your right hand, please?
I sure can.
Do you solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Go ahead, Art. Why don't you just briefly go through your credentials and go into the variances in this application.
Well, have I been accepted as an expert or?
Not yet.
Okay, so I'm the managing member of my own firm. I have a master's in city and regional planning from Rutgers University. I'm a licensed professional planner with 45 years of experience in land use planning. During that time, I've served 27 municipalities in various capacities, including planning boards and boards of adjustment. I've represented private sector clients before many more boards than that.
We can accept your qualifications.
Thank you. In preparing my testimony tonight, I reviewed your ordinance and the applicant's plan for the property. I reviewed your professionals' reports and that 2016 dismissal of litigation, and I performed a site visit about a week ago, I guess. Just to reset a little bit, the settlement granted relief for variances for the dual usage of the property for a church and a parsonage. It granted relief for a 45-foot silo that exceeded your 35-foot building height. And it also granted relief to your maximum impervious coverage, which is the standard's 10%. And I believe at the time, the initial approval was 10.48%, and it's being reduced to 10.43%, and it's being reduced to 10.18%. And there were numerous conditions associated with the settlement. One involved the addition of the second access driveway. One involved installing a sprinkler system for what was then 2 floors of the church. There was the installation of an on-site underground water tank and widening of the existing driveway, and providing a fire lane. And so what's changed is that the church is now 1 story instead of 2, but it's still going to be served by a sprinkler system. There's still going to be the underground tank with 45,000 gallons, although I think Mr. Decker talked to you about different ways to accomplish the same thing. And the other change, I think of significance, is that the location of the alternate driveway has changed. And because of these changes, the professionals determined that we need to require another D1 variance. And the planner's report, Mr. Gorman's report, says that although there's no proposed alteration of the structure, the board should reaffirm the height relief. So I thought we'd just talk about the height relief first. It was a D6 variance, and the proofs required for a D6 is that the site can accommodate the issues associated with the increase in height. Here, the increase in height is the silo, which is existing, it already exists, and the applicant is doing nothing to exacerbate the existing condition. The barn and the silo sit on a 14-acre site that's surrounded by open space and farming type uses. So this silo isn't going to deprive anyone of air and light. The fact that it's a silo means that it fits into the rural character of the area. There's no lighting associated with the silo, so there's not going to be any glare on the neighbors. The silo doesn't bring any intensity to the use in terms of any more traffic. It was going to be used for a stairway before, now it's going to be used for storage. So I think it's clear that the site can accommodate the height of the silo. Now, if I was starting from scratch, if there had been no history before the board, no settlement in court, I would have to create go through a positive criteria to justify a D1 variance. And it could be done either by the fact that the church is a conditional use, and I could go that route, or that it's an inherently beneficial use, and I could go that route. But my thinking is that the positive criteria has already been established in the settlement. And then what we're talking about are changed conditions that impact the negative criteria. So my thought was that I would talk about the changed conditions that we talked about and relate it to the negative criteria if that works for the board. So in terms of the negative criteria, I don't think the changes create any substantial or any meaningful impact with regard to the public good. The church is now 1 story and not 2, so it's a less intensive use. It still has, it still is going to have a sprinkler system. It's still going to have the underground tanks that are going to help the firefighting. The impervious coverage is actually going to be less, so that will have less of an impact. And we've had a lot of discussion about the proposed access road, which involves less grading, less disturbance, is favored by the county. And I believe the fire marshal said it works, that it was, I think he used the phrase that it was 6 of one or half a dozen of the other. I believe that's what he said. And so I don't see a substantial negative impact associated with the change in location of the road.
Excuse me, Art, it's John Stamler.
Sure, sir.
That was before he found out that there were banquets going to take place and weddings and so forth. So he did make that comment, but then later on, once he found out there were going to be banquets and so forth going on, he did.
Well, what he did say, thank you for that, Mr. Stamler, but what he did say was that 150 people were 150 people. What I'll point out to the board, I don't know how many banquets.
Yes, but let me interrupt.
Well, could I finish my thought?
I'm sorry.
Let me just finish the thought. I was looking at the conditions, and in terms of banquets and facilities like that, I don't know how many banquets there are going to be, but one of the conditions is that there will be no use of alcohol on the site. I think that doesn't mean there's not going to be banquets, but I think it would limit the banquets.
Not necessarily.
Okay, that was my thought. And if you disagree, that's fine.
Yeah, and I had a question. When you're saying 6 one way, half a dozen the other, so you could also argue that leave it the way it is. It's not a negative, correct?
Well, I understand your thinking, except that this, in terms of our engineer's thoughts, this is a county road, and this site access is favored by the county.
No, the county was okay with it before.
He didn't testify to that.
The county
hasn't
already approved. The county already approved.
The first one, not the second one. Not
Yes,
the new proposed access.
Yes, he said that. The county did approve the first access, but he also said that the county favored this access.
They didn't approve the second one.
Well, they probably haven't had the opportunity to approve it yet.
Well, right now, we don't know.
Well, I mean, Mr. Decker's testimony was that the county didn't want the first access at all, and they approved it because it was a condition of the settlement, and that they favored this access, this entrance. I think his testimony was clear on that.
We can move on.
Let's move
on. In terms of the impact on the zone plan, the only change that's related to the zoning is actually a decrease in the impervious coverage. So that wouldn't have a substantial impact. As a matter of fact, I think it would not be noticeable to the eye, and Mr. Decker has designed the stormwater so it can easily accommodate that small increase. When I say it's a decrease in the impervious coverage. And then the last proof I have to make on a D1 variance, if the church and the parsonage aren't inherently beneficial, is that I would need to reconcile the emission of the parsonage from the zone plan. And I can reconcile it in that it's a use that's customary and incidental to the church. I can reconcile it because it already exists, and I can also reconcile it because the parsonage was part of the settlement approved by the court. So it's a fairly brief synopsis in terms of the impact of the change in conditions on the negative criteria.
Thank you, Mr. Bernard.
Questions from members of the board?
No, Frank, I just make one comment that the reason for mentioning the banquets and things like that was that there were going to be more events than just a Sunday morning worship gathering of people, that there would be additional gathering of people.
Yeah, no, I'm aware of that. Yeah. Is the problem the frequency or the number of people that are attending those?
No, that's beside the point. It just there just be
Frank,
more events, more people. That's beside the point. Let's move on.
Yep, let's move on, Frank.
Okay. Okay, so let's open it up to the public for questions for this witness.
Anyone from the public have a comment for this witness? Please raise your hand. Seeing none, Chairman, you can proceed.
Okay, Mr. O'Grodnick, any more witnesses? No.
I have no more witnesses unless any of the board members have any questions, legal questions for me or our planner or our experts. I appreciate the board's time. It's kind of colorful history in this application that I just got involved with, but in my view, it's an appropriate use of this site, and this proposal, these deviations are consistent with the intent of the prior applications that did approve these variances. So we would appreciate the board approve this application. And I know the congregation is extremely excited. They've been saving up, money for many years to get their own place. And it's a wonderful congregation. I've had many conferences, and we would thank you for your time, and hopefully you support this application.
Thank you. At this point, motion to close public.
Motion to
Did
close.
we have statements?
Yeah, no, we haven't had statements. You're right. Okay, at this point, are there any statements from the public for addressing this application? Fred, would you open up for statements from the public?
Sure. Anybody from the public have a comment or statement on this application? Please raise your hand. Seeing none, Chairman, you can proceed.
Okay.
Motion to close the public, Frank.
Thank you. Thank you for reminding me. Second? Is there a second? John Stanley, second. Those in favor?
Aye.
Aye.
Those opposed, it's closed. Okay, at this point, do we need input from Mark?
Yeah, it's John Stamler. I have a question for Mark. Hey, Mark, motioning to approve or disapprove this application, say to approve, does it have to be all of the conditions that were mentioned? Or, for instance, if there's 4 proposed changes to the site plan that they want approved, and I really only see 3 that I see approved, could I motion to approve the site plan excluding the one that I disapprove with?
Yes, the answer to your question is yes. Let me go back a step, if I may, though. As I have advised the board, as with any time when there are D-variances and site plans involved, the board should probably consider this in 2 steps. And the reason is because the required vote for approval is different for the 2. For the D-variances, of course, the required approval is 5 affirmative votes. Frankly, if that were to fail, then there's really no point in going on to the site plan, because the site plan is based on the proposed uses. Assuming that there were 5 affirmative votes on the uses, the D-variances, then the board would properly move on to the site plan itself. The site plan, approval of the site plan itself, with or without whatever conditions the board might want to impose, is done by a majority vote, affirmative majority vote.
And just
Is that-
remember, there's two variances here, the height variance and the use variance.
Yes,
Okay.
yes.
With that-
To be more precise, the change in the use variance,
Correct, yes.
but that in itself is a D variance.
Okay, so exactly what do you mean by the change in the use variance, Mark?
Well, the settlement indicated that a use variance for the dual use was permitted, and also indicated that the height variance, the D height variance, was approved. But that was subject to a long list of conditions, not all of which the applicant is now proposing to meet. So this is essentially the elimination of conditions which were approved in these D variances. The change in the grant of a use variance, I should say D variance generally. Go back. There are existing D variances. They have been approved, but they're approved only subject to this rather long list of conditions. The applicant wants to change those conditions. That in itself requires a D variance for the change in the prior D variance approval.
Okay, so let's take, one of the conditions was that there be a secondary emergency road.
No, wait, no, that's not part of it. If we're making two motions, one would be to approve the use variances, right, Mark? And then the second one would go into the site plan issues, which would be so why don't we handle the first one first?
But my question is, I think we are, because if you look at the conditions of the use variance, one was that we have an emergency access. It didn't say where it had to be. But
No, that's right, Frank. And that's why we should, right, if we approve it, we're saying there should be a emergency exit or access.
Well, let me try to make an effort to interpret the conditions in the settlement. And there's been a lot of discussion about this, and properly so, because frankly, I don't think that the authors of the settlement agreement ever conceived of the fact that somebody would be back making a request to change those things. I certainly hope that if they had, they would have been a little bit more expressive about the way they phrased these conditions, and more specifically, what they thought the conditions attached to. The way the settlement agreement is set out, there is a paragraph that says what's granted, and then there's a paragraph that says all the conditions. The way that is set out, there's no way of ascertaining which conditions apply to which approvals. So I think it's only fair to interpret that all of the conditions apply to all of the approvals. Now, as specifically to the second access, the condition says, and I will read this. This is 2B, and I'm not quoting Shakespeare here. Paragraph 2 of the settlement agreement is the list of conditions, and 2B is the condition that applies. And it says, quote, plaintiff shall comply with all of the recommendations in the reports of the Chief Fire Marshal Christopher C. Weniger, dated July 29, 2015 and October 5, 2015, including but not limited to, and then sub I, this is in Roman numerals, so that would be the first subparagraph, addition of a second access driveway to the property. So the condition is not simply a second access driveway. The condition is, condition 2B is compliance with all of the Chief Fire Marshal's recommendations in those two memos, including, as I read that, that means not just a second access driveway, but the second access driveway that was approved.
Thank you, Mark. So Frank,
Yes, John?
we've done it before, right? We approve the D variances and the use, right, variance.
Mhm.
And then we need a second vote for the site plan changes,
Right.
which, as Mark just said, they want to change the site plan for the other modified version of the driveway.
Right.
Correct, John.
So we can go ahead and do the first vote.
Right.
And then like Mark says, if it's approved, fine. If not, then there's no sense to go forward, right?
Right.
So
Mr.
should we do that?
Mr. Sandler, the overlap is, as I see it here, is that the condition that I just read appears to be attached to everything, including the D variances. So the D variance that is before the board now is a change in the previously granted D variances. One of the conditions in the previously granted D variances is this condition for the specific second access. If you are changing the previously approved D variance, that incorporates the change in the second access driveway as previously approved. The overlap is that if that's approved, there would still properly be discussion when you're talking about the site plan as to exactly what the configuration should be. But the question applying to the first, what I suggest should be taken as the first vote, is whether the board is willing to change that condition, to do something other than what was previously approved, other than that specific driveway. If that were successful, then on the site plan part, the board would have to discuss the extent to which it's willing to change.
Thank you, Mark. Okay. That cleared up a lot. Thank you.
That's the case. Would you like to make a motion? Or somebody make a motion?
Well, Mark, John, can I ask one more question of Mark? Because I think I'm more confused than I was before. Can we not, obviously, I think obviously, we're going to approve the main use variance and probably the height of the silo variance. They're part of the use things. And that takes the 5 affirmative votes. Can we do that as a separate one and then tackle the secondary issues of the gravel driveway or parking lot and the secondary road? Can we do that first vote on the use variances, Mark?
The answer is yes, but first of all, I certainly don't blame anybody for being confused by this. Ms. Haynes, I believe you implied in your question is that what the board is called upon right now for D variances is essentially the reapproval of the 2 previous D variances.
Correct.
That's not technically correct. What the board is called upon is to authorize a change in the previously approved D variances.
But Mark, if we're not in favor of, let's say, one of the 2 proposed changes in the site plan, but we don't have a problem with the church and the parsonage and the height of the silo and all of that, how can we
move
vote
forward?
Yeah.
Right.
Well, again, as I was indicating when I was trying to make clear when I was answering Mr. Stanley's question, there is a very distinct overlap. There are a number of them in this long list of conditions. The one that seems to be at the fore, of course, is this question of the secondary access, the request to change the configuration of the secondary access. But a vote in favor of the current request for D variance would be a vote to change, at least open for change, the secondary access. Now, again, the overlap is, if that were to be successful, the board were willing to approve at least opening the discussion to a change in the secondary access. The configuration of the secondary access would still be an issue in the second step, that is approval of the site plan. So if, let me try to step through this. If the board does not accept the current request for a D variance, that is, does not accept a request to change the previously approved approval, then we're at an end. The applicant still holds an approval. They could go forward with what was previously approved, but there would be no further action on part of the board. If the board were to accept the current request for D variance, then it opens, in my mind, all of the conditions for rediscussion, including the possibility that the board will still impose exactly the same configuration for the driveway.
So if we vote no on the use variance, we're not voting no against the church or the parsonage. We're voting no against opening what the original application that has been approved.
You're voting to, if the vote does not succeed on the current D variances, as I say, then things are done. The current approval, including all conditions, still stand. If the board is in favor of the D variance, then all of the site plan issues, which are really seem to be primarily, if not solely, site plan issues, all of those will be subject to new discussion. They could be, the same conditions could be imposed, or modified conditions could be imposed.
But Mark, when you say open for new discussion, that means between the board members?
Yes.
Open, yes.
Yes, absolutely.
Okay.
Absolutely. Again,
So,
go
ahead, sorry.
Again, focusing on the one issue, not because I picked it, but it seems to be the issue of most contention, which is the question of reconfiguration of the emergency access drive. If the board accepts a change in the D variance, which is the first vote requiring 5 affirmative votes, that does not mean that the board is automatically accepting the proposed change in the emergency access.
Correct.
It simply opens it for discussion, and the result of that discussion could, at least theoretically, be that the board will, as a matter of site plan approval, impose exactly the same condition or a different condition.
So hypothetically, is that the legal way of doing it? I can make a motion and we could accept the change in the use variance, right? So, and then for the second motion, I could hypothetically, I don't like one of maybe the 4 conditions that were talked about. I could say, make the motion to approve excluding that one.
Yes, when you're talking about the second vote, you're talking about the vote on the site plan.
Yes.
Yeah. Yes.
Okay.
Once you get to the site plan issue, as far as I'm concerned, all site plan issues are open for board's discussion and approval or disapproval.
Great. Okay, Frank, I'm ready to go.
Oh, wait, you're not speaking for everyone, John. Just remember.
What are you talking about, Curtis? I'm not talking for you.
No, I said if you're going to make a motion.
Okay.
What do you mean? I don't understand, Curtis. Explain yourself.
No, you're sounds like you're talking about putting in some stuff here, and I'm just saying that's your opinion on that. It's not the whole board's opinion.
Curtis, why don't you listen? What am I adding?
Well, can I make a motion?
Go ahead.
Go ahead. Go ahead, Curtis.
All right, I'm going to make a motion to deny this.
Okay. Is there a second?
You know what? I'll second that. Mark, now that still means that the original approval and court settlement stands, right?
Yes, if the board rejected the request to change, I do not see how that impacts the previously granted approval.
Okay, so so we're not voting against the church or the parson. I second Kurt's motion.
Can I just say something before you do that, Jackie?
No, I
But
second.
you have a motion.
We already did.
Second, it is presumably, Mr. Chairman, you'll open it for discussion at this point.
Okay, open for discussion. Input from the members of the board.
No, what I was gonna do was approve the variance, the change in the variance, and then, not that it matters because we have to vote on this, motion from Kernis. But when it came to the site plan, I was going to motion to approve the second floor silo, the change in the parking lot from pavement to gravel with wheel stops, keeping the 88 paved spaces, the condition with the drop-off point and space for folks by the handicap spaces, and the applicant would be adding sprinklers and water tanks for the facility. But I would not be motioning to approve any type of change to the emergency access. So that was going to be, and that's why we're opening.
John, I'll tell you what, I have a problem with not paving the parking lot. So I had a problem with two. I think the two major changes they wanted, but this stops all that discussion. You know, we didn't even talk about, okay, we'd have to include the silos. One of the conditions would that there would not be any symbols or flags or banners put on it. We'd have to go through all those criteria or items.
I thought the silo is just the height. I thought the silo was
Yeah, it
just up
is,
for the height.
but I'm saying one of the, if you remember back, one of the conditions, if you will, was, you know, nothing, no signs, symbols, flags or things on the side. We'd have to go through all those sorts of things again.
Why?
This way,
Why? I thought we weren't changing that condition though, Chicky. We
yeah, but
were,
we still have to, well,
no, they weren't, no, that wasn't, that's already, everything's been approved. They were just, the ones that I just mentioned were the ones that they were changing, and that's why I was going that route. They,
Mark, help.
Those
Wouldn't we
flags
have to re-stipulate all those things again?
If
Well,
you
maybe
get
not.
to- if you get to the question of conditions imposed for the site plan, the answer is yes, you do need whatever conditions the board approves. However, that could include, for instance, all of the conditions that were previously imposed, just you know,
Okay, yeah,
as
okay.
a single entity, as opposed to laboriously going through each one.
Yeah, okay.
all right, Chicky, we just keep all the previous.
Well, we have a motion and a second just to leave things the way they are.
And so as part of this, anybody else have any input into this discussion? I guess I had my.
Wait, I actually, I'm kind of,
This is Phil Solili. Do we have a motion on the floor right now?
Yeah.
Yes.
And has that motion been seconded?
Yes.
yes.
Okay. What's the next step?
No, we're discussing the motion because it could be changed as per the outcome of the discussion.
Yeah, discussion, and ultimately, when the board is satisfied that it's completed its discussion, then a vote.
Okay.
And I, just because this is one of these sort of double negative things, the motion, as I understood it from Mr. Sirachi, is to deny on the D variance request, the D variance request being to change the previously approved D variances. The result, first of all, a vote for that motion would be to deny any changes. The result of that, as I've indicated before, would be to leave in place the currently approved uses, and the currently approved height variance, but with all of the conditions as currently approved as a result of the settlement.
And Mark, what would be the required vote on this?
This is a D variance vote, so, well, this is a vote to deny.
A
So
vote, yeah.
we simply have to see what happens. If there is a majority to deny, then it's complete. If there's not a majority to deny, then presumably the chairman will ask for whether there's an alternative motion.
Okay, okay.
Okay, we're still discussing this, right? Now, I can see why I dropped out of law school my second year. Going back,
It is a loss to the legal profession.
believe me, it's a big game. Okay, so going back to the original conditions in the settlement with the court. Okay, the condition was that there'd be a secondary access drive. It didn't say what it was, and at the time we didn't have a site plan, so we didn't know where it would be.
Mr. Chairman, I'd never like to interrupt a board member, particularly the chairman. But as I've indicated, I think that a reading of the complete condition is that it is in fact the secondary access drive that was previously approved.
Right, but that was done better part of a year later, so nobody knew where that drive was gonna be at the time. We didn't have a site plan. We only approved that during a site plan.
Well, when I say that, it's because the condition is based on the chief fire marshal's recommendations in those two reports.
Yeah, but if you go back to his report, he doesn't talk about a secondary road.
You have the advantage on me. I can't bring them completely to mind. It was my understanding that his recommendation was for what was ultimately approved.
Let me go back to.
Do any of the other, do the board members have anything else to discuss on this motion that's on the floor right now?
Yeah, I'm still talking.
Yeah, Frank is bringing, yeah. You have something other than the access, Frank?
Okay, yeah, so anyway, I see a request from the applicant to do three or four things, to change the inside of the building, to put gravel on the lot, and to, change the location of the emergency access road. I would probably, if we got to site plan, vote for at least two of those, okay? If we deny this, we deny everything. He can't even change the interior of the building.
No, wait, Frank, I'm going to
No,
interrupt.
that's not true.
Patrick, can you please step in, because what Mr. Maskey said was that the change inside the barn can be done administratively. Is that correct?
That can be done administratively, yes.
Okay, so that's not part of this whole.
Okay, so we're coming down to two things: a gravel parking lot and relocation.
Correct.
Well, hold on.
Correct.
Patrick, can the sprinklers also could be done, like Chicky said, administratively?
No, that cannot be done administratively, because that was tied into the fire marshal's original comments as part of his original memorandums back in, as part of the stipulation.
Yeah, that's part of the original, John.
That's why I brought things to this attention to the board, that if they're doing any altering of the sprinkling or the pump house or the fire suppression, then it needs to be included. But from what their testimony was provided tonight, it sounded like it was going to be still remaining a 45,000 gallon tank. And depending how the building codes and whatnot, that it's going to be architecturally designed to do the same thing.
The condition revolving around sprinklers is perhaps even knottier, believe it or not, than the question of the access drive. The particular part, which I think people are focusing on, is 2B(i), which says installation of a fire sprinkler system on both floors, including the silo of the church sanctuary building and the adjacent building containing classrooms. But remember, that is a subparagraph, again, under the overall paragraph that says that the plaintiff has to comply with the fire marshal's recommendations.
Correct.
In the best interpretation I can give to the board, and it is an interpretation, it's not expressed in a way that I can say definitively I have an answer. But my best interpretation is this reference to both floors is, in a sense, surplusage. That is, it refers to both floors because that was the proposal at the time. The ultimate purpose of this condition is compliance with the fire marshal's recommendation on sprinklers. And if the floor layout changes, and I agree with Mr. Gorman that can be done administratively, then I think that it would come back to the fire marshal to determine what sprinklers are necessary. I'm not a fire marshal. I don't have experience in the area, but I can only assume that if the fire marshal is presented with a floor configuration that is a single floor instead of two floors, it would necessarily mean that he would make a change in what he would be asking for.
So again, it boils down to the paving or not of the parking lot and the access road.
So by disapproving it, right, those two would be, right, no changes would be done. So it would have to be a paved lot and the original fire access.
Frank, can we take a vote?
Let me just say, I don't want to be voting against the church and the house on that property. I don't want to be voting against the height of the silo, and that's, I think, what.
No, we're not.
No, Frank, we're not.
It gets left with the original settlement. If we vote no on Curtis's motion, then the previous one settlement, all of that is in play.
That is a correct statement. The board is not called upon, nor honestly do I think the board could be called upon at this point to somehow take away that which has already been approved for the church, in this case approved through a court settlement, but whether through settlement or not, it is a previously granted approval.
Okay, so again, the motion is.
Motion, as I understand it, is to deny the request for D variances. The request for D variance is to change previously granted D variances. If the vote is in favor, then the applicant would retain its previous rights and there'd be nothing further for the board to do today.
And if I wanted to go on and consider site plan, then I should vote no on that, right?
Correct.
This is yes, yeah, this is yes to approve or yes to deny.
Yes to deny. That's sort of the double negative.
Does that still require a 5-2 majority?
Not this vote. This vote is not to approve. So we haven't gotten the question of getting 5 affirmative votes.
Right.
If this motion receives a majority, then let's cope with it then. For the record, I would want to have suggest the alternative motion so we can get the direct vote on it. But in effect, if this gains a majority, that is, if it gets 4 out of 7, then one assumes that an affirmative vote couldn't get 5 out of 7.
Right.
Well, Mark, let me ask you this. If we get 3 out of 7 yes to deny, then technically that gets approved. But by the alternative, if then there's a motion to approve, you have 3 negative votes, you still don't have your 5 to approve.
No, the vote now, if it does not get a majority, this motion fails and we have to move on to whether there's an alternative motion.
Yeah, okay.
So let's move on with the vote.
Okay, roll call, please, Tina.
Yes. Mr. Stamler,
No.
Ms. Haynes,
Yes.
Mr. Sirachi,
Yes.
Ms. Salili. Phil,
Unmute yourself, Philomena.
I apologize. I voted yes.
oh, okay. Mr. Valchek,
Yes.
Ms. Erickson,
Yes.
Chairman Herbert.
No.
Motion is denied.
The motion is to deny since it received 5 votes. I think that clearly demonstrates on the record that this is not approved by 5 affirmative votes. In fact, it was denied by 5 affirmative votes. Mr. Ogrodnik, just so that if there was any question on the record, obviously I'd like to hear your opinion on that. That's the way I see it.
I don't see it that way at all. I'm not so sure why this wasn't considered as a completely separate and new application. We don't believe there is a use variance for the parsonage as well as the church. We believe that there's accessory use. We've detailed that in a legal brief, so there's no use variance. We also don't believe there's a D6 height variance because we're converting the silo into a steeple and putting a cross on top of it, which is protected speech. So that would leave only bulk variances. I disagree that simply because there's a settlement agreement, although I agree that we have an enforceable approval, I disagree that this application should be treated, and I had multiple discussions with your office as well as Mr. Maskey, that this should be a separate application, new application. And again, we don't have the use variances or the height variances. So I would ask that my legal brief that I submitted be put on the record. I had submitted it as part of the packet. And I just disagree with your legal analysis pretty much, on multiple points with respect to your conclusions.
Well, you just give me a moment, because first of all, that is not what was presented tonight. With all due respect to your position, which I understood, but I disagreed with at the time, that is not what's been discussed tonight. So
why is there a use variance, Mark?
There is a request to modify the previously granted use variance.
No, I didn't submit it as a request to.
Well, that's why I'm going to go back to
the use variance application.
That's why I'm going back to
it as a land use application. The board determined that a use variance and a height variance were needed, as well as a D1 variance to alter the terms of the settlement agreement. I disagree with that. I think the parsonage is an accessory use.
Your position
law to support that position.
Sure, your position is entirely clear on that. I understand it. That is not, however, the application that was presented tonight. And I understand implied in your statement is you don't think you should have been asked or required to make that application. But the fact is that is the application that was presented tonight. So that's what we have to vote on. Separate from that, of course, you're entitled to argue the point that you shouldn't have had to do this, and you don't have to go through this part of the process. I do point out you'd still have to make your request to modify the site plan, but that's another issue. As I understand the application as it's presented, again, with all respect to Mr. Ogrodnik's position, he shouldn't have had to have presented this. The application that was actually presented was, as I stated it, and it has been denied. Did we lose a board member? Ms. Phil?
No.
No, she's still on.
Okay.
I don't see John Stam. Oh, yeah, he is. I see you, John. He's
Okay,
muted
Frank,
though.
what do we have left?
Okay, so I guess that concludes the application hearing.
It does. That is my understanding, since this is not open for rediscussion on site plan issues.
Right. Okay, so that's it. Sorry.
Yes.
Okay.
Motion to adjourn, Frank, or what?
What do you say? I just want from Patrick what's coming up at the next meeting.
Next meeting is October 7th. We had Timco Associates on for that meeting. That was carried from our first September meeting. Without notice, they're good to go. And then we will have Pilgrim River on for that meeting also. For that one, and Mr. Ogrodnik confirmed that we're going to have that information.
Yeah, I believe everything's been submitted to the board.
Yeah. Yeah, so, and then November 7th, we have the minutes application on that date. And we're anticipating to have quite a few other homeowner applications hopefully by then, so.
All right, Patrick, keep them coming.
Yeah, there's enough work. I'm grateful for work, I'll tell you that much.
Okay, all right.
Okay,
Have a good night, everybody.
Motion to end the meeting, close.
Motion to close.
Is that all in favor?
Aye.
Aye.
Thanks, Tom.
Close. See you next month.
Take care, everyone. Have a good one.
Mark,
Yes.
you want the transcript?
Oh, yes, definitely. We'll need a transcript.
I thought so. I'll get on that. Thank you. All right, guys, I gotta go. My dog is barking like crazy.
Thank
It
you,
was
Tina.
annoying. Take care. I'll see you at the next one.
Tina, this, well, we need a transcript. I don't see this one as any huge rush. I mean,
Yeah, I still have another township to do, but I'll get to you by the end of the month.
yeah, anything else that you have for Hillsborough, I don't know if you do, would be to me more important.
Yeah, I don't think I have anything. I think I'm all caught up with Hillsborough. And Patrick, I'll be covering all the planning board meetings until further notice, okay?
Oh, because, yeah, well, okay. I mean,
Tina, hopefully I'll be at the next couple. Maybe it'll run a little smoother.
Oh, yeah, well, whatever. I just love a good challenge.
I had to get my steps in.
So I'll be seeing you guys then, all right?
All right, guys.
Thanks,
Okay,
Tina.
good night, everyone.
Take care.
Wait, Tina, you be on tomorrow night?
There isn't one tomorrow night.
Historical.
What?
I thought
We have
planning board
historical
tomorrow,
commission.
Wait,
Isn't
one
there a
person
planning board
talk at a time.
right? I'm sorry.
There
there
is
a planning
nothing
board?
on, hold on. There's nothing on tomorrow night.
Oh, I'm sorry. I'm covering all these meetings now, so.
You know what? Don't
Anyway.
feel bad. Don't feel bad. I've got everybody's night meetings. But I believe the 24th was canceled.
Yeah.
The 24th was canceled,
Correct.
okay?
Okay.
So I won't see you until, oh, I don't have my next month's. I'll see you at the
Well-
next one.
Yeah, we'll be in touch.
Yeah, definitely. All right, guys, have a good night.
All right, thank you.
Bye-bye.
Good night.
Good night.